Hello, everyone. It is Mo in the Deep End, and we are trying to finish up this trial today. Hopefully, we will get to closing arguments and everything, and we know the verdict. And I don't believe that the judge, I did see that Timothy Fairder tried to ask for like a GPS monitoring so he could be free on bail before sentencing. I don't think that the judge is likely to grant that. I don't think that that's appropriate, to be honest with you. Good morning, Charlotte. Yeah, this is a hard one. Honestly, after today, if we don't get it all done, I am putting this one to rest. I feel like I've done my greatest. I've done my best to try to get this done, but it is just not dunning. um, but as far as I'm concerned, I don't think Timothy should get out between sentencing and uh, or between now and sentencing. I don't think that's appropriate just because he's already been sentenced. The jury found him guilty. They can appeal whatever they want, but the jury did make their decision. And, other people don't get that sort of, I was a good boy, let me out until sentencing. I mean, it's up to the judge. But as far as I'm concerned, he's now convicted and, that's where the cookie crumbled. And, I'm not a fan of the way the defense went. I think we've been kind of very clear that the defense was not great on this. So I I essentially just want to really finish up this particular witness. I really enjoyed her kind of take on this. This is let me Dr. Sheila Rappa. So she is a forensic psychologist who works with yeah, it is interesting. I could see it going both ways. I do understand now, having watched all of the doorbell video camera, and then, Timothy not taking the stand, and again, I agree with most of the chat that had the defense gone with, "These are the steps we took to try to find help for our son," versus, "Our son was the bad guy," kinda thing. I think that would have played much better. Uh But without further ado, let's get going on this case. But I will say one bittersweet note for me, at least, is that I do wish, because I really do like this particular therapist, and she seems like, had they been able to contact her and gotten the child in with her, what a different outcome this would have been. It is, kind of bittersweet what could have been, at least for me, because she does seem to have, just a very sort of in-depth, kind, you know, wisdom about this subject that I think she could have given to the family had they gotten a hold of her as a resource.
Anybody else may have said to you, because that would be hearsay. But if there's something in the records that can form a basis for you to answer the question, I'll allow you to do that. Okay?
Thank you, Your Honor. Based on the records that you reviewed and coming to your various opinions in this case, is there any evidence that the Ferreters were recommended those treatments that you just mentioned?
No,
Is there any evidence in the records that you reviewed that they were recommended inpatient treatment for attachment disorder?
no,
Is there any evidence in the record that the Ferreters were recommended to go to a specialist for attachment disorders?
no.
And just so we're clear, Ms. Morad, you're talking about the records that she reviewed, not in the record in the global sense
Not
of
that
this
you guys
proceeding.
have
Yeah,
records,
yeah.
just the ones you have. Yes. All right. I want to go into, Your Honor, my next opinion does require me to approach. I'm wondering if it's a good time for a break.
Yeah, it is good because we've been going about an hour and a half this morning. So we'll take a break, 15-minute break. It's almost 10:30. We'll be in recess until 10:45.
Yeah, it is what I think.
All right, everyone may be seated.
I think the difficulty in this case is you have so many different parenting is so individualized. You have parents that would never raise their voice. You have parents that routinely raise their voices. You have parents that, do believe in spanking. You have parents that don't believe in spanking. So when you are asked to judge a parent on a snapshot of parenting, you know, along with, again, video that shows the dad being an utter jerk face, dill hole. He really does sound like a jerk face, but without the accompanying, you know, context of what the son is obviously doing. So it's a reaction sort of cycle. It's easy to understand why the jury did make their decision, but it's also something that is really just so hard.
All right, you need to approach?
Could we just do it?
We can do it.
Here. So, Judge, in my opinion, the court has sort of made a preliminary ruling on this, but I wanted to readdress it before I asked Dr. Rappa. So, in the cross-examination, actually, I think it was in the direct or redirect examination of Wade Myers opined that when you remove a child from the environment that they're in, that's causing issues with their attachment. So specifically, and we listened to this yesterday, so Wade Myers agreed that he has probably an attachment disorder from his early childhood when he was adopted. He then said that it was, quote, brought back by the Fereders. And he then said that if he is placed in a different situation or environment, or children with attachment issues are placed in a different situation or environment, you expect to see an improvement in their behavior. And so I believe, based on the records that Dr. Rappa has reviewed, that at the very least, the defense should be able to counter that position to show that that improvement has not in fact happened, because there is an issue here of the persistent reactive attachment disorder and how the Fereders couldn't have really done anything to improve it. And it is direct rebuttal to what the state's own expert testified to. So I would like to get into that, and I'm sure the state will be objecting.
All right, so Ms. Coakley, make sure you use a mic and say what your position is.
Yeah, I mean, the state would object. I think that there is a fundamental difference between saying generally this is how it is addressed, which is what Dr. Rappa has already testified to, that generally how it's addressed is that it focuses on the parenting in a nurturing, safe parenting environment. There's a fundamental difference between that testimony and saying that that would have solved it in this case, which is not what his testimony was. He testified generally. Beyond that, it's much more complex and nuanced than the defense wants to make it seem. It's not an automatic solution. I don't think any psychiatrist or psychologist would say that, especially after 3 years of additional trauma perpetrated by the defendants, then to go into every single thing that has occurred to the child after.
So what is the legal basis of your objection? Is it foundation? Is it relevancy?
It's improper character evidence, Your Honor. And whether or not the child in this case was cured after being removed from the parents is not a relevant determination for the jury. That doesn't have any bearing on whether or not the defendants committed a criminal act in this case. Whether
That
or not
sounds like a relevancy objection to me as well.
Right. It's like nuance. So it's like the idea is first that it's improper character evidence that confuses the issues and is prejudicial because it gets into such a complicated issue. But so it's, Your Honor in limine said that is not permissible. It's improper character evidence.
And that's right. And that's why Ms. Murad said I'd already preliminarily ruled on it.
But beyond that, it's not even relevant because like how easy or how hard it was to manage their child is not a defense to the criminal charge here. And so whether or not he was able to or continue to have behaviors after they were removed is not relevant to the determination of the defendant's intent or knowledge in this case, or whether or not they committed a criminal act.
The state's attorney in this case.
And I'll help you out with at least the concern I have is I think it's completely irrelevant whether the child gets well or not after he's removed from the home, because I agree with the state's position that whether the child gets better or not does not decide the issue of whether the treatment and the conduct of the parents in dealing with the child prior to the child's removal was appropriate or not to the circumstances. You've testified as to the circumstances that, or you've had your witness testify as to the circumstances that existed while the child was at home, and that was with the reactive attachment disorder. So that's appropriate, but now, and that's relevant because that's what they're dealing with in real time, and it guides and determines their conduct, their response to a minor child having reactive attachment disorder. But what happens after the child's removed, I have a real difficult time connecting the dots because it's irrelevant to the parent's conduct that they pursued while the child was with them and while they were dealing with the issue. So that's my major concern, is it's just not relevant. And why should I change my pretrial ruling already made in this case that I wasn't going to allow this area of an opinion and conduct to be looked at.
So the reason I think the court should reconsider its ruling is because the state has made it relevant. Everything that the court is saying in the state's sort of argument in the second half of their argument is the same thing that we litigated in motions in limine. We are now in a different posture. The state could have instructed their expert, do not say anything that could create an issue with what's happened after the fact. We all do that with motion in limines, and we instruct our witnesses, don't testify like this, don't bring this up. Now it has become relevant. So the reason it's not improper character evidence, improper character evidence, as the court knows, is only inadmissible to the extent that it goes to show propensity. That's not what we're doing.
Okay.
They have had an expert.
Can we take a moment to realize that this lawyer right here, Madam Lady Lawyer, I forget her name, Miss Murad, is so much quicker on her feet. Cousin Lemmy, who I don't even remember his name, would have been and so, and let me talk to my defense co-counsel. She is on top of it, and if not for her little bow tie shirt, which for the love of Murphy Brown, I just don't like. Look, she pulls it off. She looks cute. Anything around my neck would bother the ever-living snot out of me. So it's a personal choice. She looks beautiful. I am not dogging her outfit choice. It's not for me. I thought we had banished that to the bowels of hell of the 80s. But she is on top of it. She's able to argue her point, and Cousin Lemmy could not argue his way out of a paper bag. And he has a death penalty case. Whoever that person is who is his client, I hope you have made yourself right with the Lord.
A doctor testify that when you remove a child from that situation, they will get better. And he may have said that generally, but we're in a case here about his behavior and whether or not the Ferreters are guilty or not guilty. Now, I understand the state's position as to, these are perpetrated by the Ferreters. Their version of the theory of their case is not, I do not have to abide by that. I certainly understand that there are relevance objections and everything, but their version of their case, they can present. I don't have to present that version.
Okay. I recall well the underpinnings of my ruling pre-trial on this, and I can tell you that my ruling was informed by much more than just a relevance consideration, but it was also informed by significant case law that had been presented to me regarding the privacy interest of the victim in this case. And it was because of that and a substantial amount of authority that weighed in heavy favor of not allowing this type of information to be pursued with a victim in general, but a child victim in particular. So I'm going to sustain the state's objection, maintain my pretrial ruling and my order in limine on this. So with that, I'm going to do you need anything else? I'm going to give you a break until for you to
Can I
continue.
just proffer the question?
You can proffer the question. That'll be fine. Go ahead, Ms. Murad.
Thank you. Wade Myers opined that when you remove a child from an abusive environment, you expect to see improvement in their behavior. In general, do you agree with that? We're just proffering, so you have to answer it. When would you not agree? Are there circumstances where that's not the case?
Sure. If the child has real significant psychiatric problems, then we're not going to necessarily see it remit just because they're put in a different placement.
In this particular case, is there evidence that has in fact improved since his removal from the Ferreter home?
I'm just going to object because
This is proffer.
I know it's proper, but we're in open court here. This information was protected pursuant to multiple privileges, and so now to play it on a televised.
I think that's a fair objection. Let me have both sides approach.
And I will say this is a hard case, but I really have liked how very, very thoughtful this judge is about, even though they've used this child's name, I mean, how thoughtful this judge is, even though I don't like her voice, how thoughtful the prosecutor is, in keeping these children's sort of identities and things protected as much as they can. This is a rough case, you guys, and we have been doggedly trying to finish it. And then I am texting my friend to see if
All right, so the court is going to sustain the objection. It's without prejudice to the defense to do a written proffer
the
with a confidential
motions
filing, because
or
the court has
the
found
paperwork
previously
have been put
that
up on the Carroll
the
County.
minor victim's treatment post removal from the home is protected.
If the Carroll County website has put up any of the motions that were filed yesterday. And since I can't do that and talk at the same
protected
time, I
information, and it
will.
would violate his privacy interest to have that disclosed publicly. So I'm maintaining that ruling, maintaining that protection that I originally ordered. However, I also acknowledge the defense's right to put on a proffer of what evidence it would have submitted, but for my ruling, and I will allow that to be done in a way that it is not public at this point. You can do a sealed proffer for filing that will become part of the record going forward. Ms. Murad, anything else before we've chewed up the break, but I'm going to still give you 5 or 10 minutes. Anything from state? All right, so we're going to take a brief recess. Ma'am, you can step down, stretch your legs, but during the break, you're not to discuss your testimony with anyone. You understand all that? All right, thank you. Court will be in recess for another 10 minutes. All right, everyone may be seated. Ms. Murad, you ready to continue?
I am, Your Honor. Thank
All
you.
right, Mark, you may bring the jurors back out. Yes, sir. Ms. Moran, I'm going to, instead of doing a written proffer, we're going to do a sidebar, and we'll do the proffer at sidebar when this witness is done.
Sure, no problem. Whatever the court prefers.
All rise. All right, everyone may be seated. Ms. Murad, you may continue.
Thank you, Your Honor. Dr. Rappa, we talked about reactive attachment disorder. I now want to turn to something else that you mentioned during the course of your direct examination. Do you have an opinion as to whether one has symptoms indicative of oppositional defiant disorder?
Yes.
What is that?
Approach.
And I'm waiting to hear back from her to see if those motions from both the lawyer representing the former defense and then anything from the former defense of Richard Allen was posted yet on Carroll County's, public service or public records things, so I can pull those off and we can go over those. What I will tell you is random scuttlebutt as far as, what has been heard around sort of defense attorney row, and take this with pounds and pounds of salt, is that this is
The
not
objection
what
is
the
sustained.
defense attorneys wanted to do.
You may continue, Ms. Moran.
Do you have any opinion as to whether one has PTSD?
Yes.
What's your opinion?
I do believe he has signs and symptoms consistent with complex post-traumatic stress disorder.
What is complex? Well, let me start with this. What is your opinion as to when that complex PTSD started?
I believe that it started when he was an infant, when he was a very, very small child, up until the time he was around almost 2.
Explain that to us. How are you able to make that determination?
Well, post-traumatic stress disorder in infants is something that has recently been looked at. People thought, oh no, they're newborns or they're young children. They don't remember anything, and nothing in their environment really impacts them, so it doesn't matter. nothing really can be further from the truth when you start to look at it and, and when it is studied.
Oh,
So
here, let me
children
move
that have
these.
had
Sorry, I
adverse
didn't
childhood
realize.
experiences, whether it's trauma or severe neglect or medical neglect, anything like that, can cause signs and symptoms of post-traumatic stress disorder in infancy.
So when you're determining whether or not a child has complex PTSD that's rooted in issues from infancy, are you relying on the DSM-5?
No, normally what you're going to rely on when you're diagnosing a young child is called a diagnostic classification 0 to 3. So it looks at young children and then it looks at what behaviors young children might exhibit, as opposed to the DSM, which does talk about children with PTSD, but really doesn't deal with early life experiences.
Is it your opinion that the ferreters caused the complex PTSD that one has?
No, I mean, I think that it's a complicated mix of reactive attachment disorder and complex PTSD due to everything that he went through from birth until like 17 months of age.
And without discussing the substance of the records or any hearsay, is there evidence prior to about May of 2018 in the record that supports these that has symptoms indicative of complex PTSD and reactive attachment disorder?
Yes, and sometimes these disorders mirror each other. So when you have young children, they really can't communicate. So the way that they are communicating is through their behaviors. Therefore, if you see some children, that's why you'll see lots of times when you're looking at records of young children, you'll see that different providers are giving them different diagnoses because some of them are similar or they mirror each other. Because again, children can't tell you what's going on with them. You have to see it through their behaviors and what the parent is experiencing at home.
We discussed earlier on, I guess I'll call it part one of this direct examination, about congruence and trust. Could you remind us about that, about the role of trust in human relationships?
Sustained.
So without reminding us about what you said, how is trust involved in the parent-child relationship?
Throughout you raising your children, trust is involved. You're teaching your children that you have to be able to trust them. And as they get a little bit older, you're giving them a little more independence. You're watching to see how they handle it. If they start to handle it badly, then you take away a little bit of independence. And so that trust between you and the child grows in that way. You have a teenager and you let them use your car and they stay out too late, you take the car. I mean, that's good parenting. That's just parents that are teaching children, hey, I'm gonna let you get a little independent, but if you show that I can't trust you, I'm gonna pull back. And that's exactly how parents raise children that then learn to be responsible and accountable.
What behaviors are associated with a lack of trust, or someone that, perhaps someone would not feel comfortable trusting?
Sustained.
What evidence in the records have you reviewed that, well, let me ask it this way. Do you believe that a lack of trust, and I'm talking about this in terms of like psychology, that, your field, is there evidence in the record of doing activities that are not trustworthy?
Yes.
I didn't catch the last part of that. That are not what?
Trustworthy, just because we're using that language in the psychological sense. Judge.
So is this a psychological opinion you're asking, or just her?
Psychological opinion. Judge.
And what's the basis of the objection? Sustained. Commenting on the credibility.
Not commenting. So let me start with this. What are behaviors that indicate that's a lack of trust?
Sustained.
If you have someone who is doing things like stealing or lying, are those behaviors that show that, they're tied to like manipulation or dishonesty? Is that fair to say?
Sustained. Let me have you approach.
Again, where we could have gone with this is all the things that the parents did to try to get him help instead of painting the son as the bad actor. I really didn't like this defense. Again, the son had a lot of difficulties. I'm not going to lie. My youngest has a touch of the oppositional defiant disorder. If you ask him to do something, his first and greatest, idea is to ask you or to tell you no. We have to, consistency. If that means it takes, an hour and a half to do a 5-minute timeout because that's what he has earned with his behavior, then that means we sit there for an hour and a half to do a 5-minute timeout because he can't learn that he can get out of it by pulling shenanigans. And it's exhausting. I'm not going to say that they didn't have a hard road, but instead of what they did, this defense is bollocks, if you ask me.
right, the objection sustained. You may rephrase, Ms. Moran.
Does trust affect how a parent responds to a child?
Yes.
Explain that to us, please.
Yes. So as a child proves themselves to be more trustworthy and doing things that are, they're accountable and they're responsible, then the parent learns to trust that child, gives them more independence, and, the child moves on into adulthood.
In your review of the records in this case, is there indication that the Ferreters responded to that lack of trust from?
Objection and speculation.
Overruled. You have to answer that with reference to what you actually viewed as far as the records that drives your opinion or answer.
Go ahead.
So will you ask it one more time?
Hello
Or is there
again,
evidence in the
Christine.
record that that sort of
Thank you for
the parents'
joining us
response
today.
to that lack of trust happened in this case?
Yes.
Without discussing the specific information in the record, explain to us how you come to that conclusion. I know that that's hard.
It's hard. So there would be behaviors by whether it was at school or at home, and those behaviors would elicit a consequence.
Is there, how do parents, again, I'm talking about in psychology, when a parent sees sort of a lack of trust, how does that parent respond?
Normally, what you will see is a parent that tries to gain control of that child. So the more the child seems out of control, or the more the child seems untrustworthy, the more the parent then tries to put control on them, put external control around, or keep them somehow, safe, or whatever the parent is going through at that time. So I think the parent's initial reaction is to clamp down and be more controlling of a child that they feel like is out of control.
Is that a normal or natural response by a parent in that type of situation?
Yes, in my experience working with parents, that's the first thing they try to do, is to see if they can't gain some control over a situation they feel is out of control.
I now want to get into another opinion of yours. So you did, in fact, review the trial testimony and the deposition of Dr. Wade Myers, correct?
Yes.
And Dr. Wade Myers testified.
And I mean, that is great for, like, if you ground your child because they stayed out past curfew. This does not explain, creating a structure that locks from the outside, that has its own sort of, one-way camera. And I get it, but again, it's like all of the steps that the situation could have been avoided, and it feels like I am watching a slow train wreck with all of these steps that could have been avoided. It's just
Testified that the Ferreters engaged in malicious punishment. Is that correct?
Yes.
Do you have an opinion as to whether or not the Ferreters did, in fact, engage in malicious punishment?
Yes.
What is that opinion?
I don't believe that they were malicious insofar as they were deliberately trying to abuse.
we need
and
more
hurt
fry
their
cuteness.
child. I think that they were responding to behaviors that they were very concerned about, and they were trying. It's almost like they went into a let's contain and monitor and make sure that nothing's going to happen. Did they do something appropriate? No. Did they handle it appropriately? No. But I don't think it was just an arbitrary, I'm going to abuse this child, be cruel to this child for no reason. I think in their
What I think I might do, and I don't know, look, you miss 100% of the shots you don't take. What I might do is reach out to this doctor and see if I can interview her about what her advice would be to parents that are struggling with this. Because I think, I mean, obviously she can't give out real advice, but, I think we can all agree that the parents went about this the entirely wrong way. But I think maybe a lot of us parents, there is no guidebook. There is no guidebook for parenting. And, none of us would put our kids in a lock box or anything. But, what do we do when our kids say no, or they're, in that, terrible four-nager? Because I will tell you, as a mom of 6, I've never really been bothered by the 2s. For me, it was always the 4s. It's always the four-nagers that you have to worry about, because they are like, do it my own self. I do it my own. The sassy four-nagers have always been my thing. But it could be completely different for every family. So, and she might be way busy. So I might try to contact her and see if she'd be willing to talk on my channel about, just some resources that families that are maybe struggling can look at in their state. You know, just to see, hey, I'm at my wit's end. I need some help. What can I do? And she might be super busy, but she might give me some resources that I can go ahead and, give out to you guys. So that'll probably be a list of something that I can do this weekend. Let me find my notepad of awesomeness and write that down and make sure. Swear to all holiness, I can ask her why it is my children feel the need to steal all of my pens. Maybe I could ask her that. That would be awesome. But Dr. Sheila Rappa, and she might not respond back. That's okay. I mean, Turtle Boy didn't, but he talked to Dave. And you know what? If she wants to talk to a bigger channel, that works out too. But giving families maybe some better, places to look for, because I'm sure not families aren't struggling like this particular situation, but we're seeing more and more families stressed out. The economy is not going the greatest. I mean, we have stressors out the yin yang. I'm sure just having a professional give us a little bit of advice about resources that could help families, even myself, because like I said, my youngest does have a little bit of oppositional defiant disorder. You know, things that would help when you're a little bit at your wit's end would be awesome. So I will try that this weekend. Like I said, is a shot in the dark. I don't know how busy she is. She seems, but I I like this lady. I really do. I think she's personable, she's very nice, I think, and she seems very knowledgeable. So, maybe she has time or maybe she can point me in the right direction. And that would be great. And then I can give that information to you guys because I know these are really challenging times. People are living, paycheck to paycheck. It's not an easy time. We have people with a lot of things on their mind and kids are coming out of, COVID or the thing that we're not supposed to name. There's just a lot of stresses and, maybe she can give us some resources. So I will try to do that this weekend and I will let you know what she says.
In their mind, they were trying to contain some behaviors and keep everybody safe in the process.
There are records that indicate that the Ferreters went from sort of provider to provider, perhaps not staying with one for a very extended period of time. Do you have an opinion about that?
Sure, I see that happen all the time. Unfortunately, I wish I could say that all mental health professionals are excellent at what they do, but that's not necessarily the case. And sometimes you go to a provider that, what they're dealing with is a little over their head, or what they're not trained in evidence-based treatment. So they're trying to do talk therapy with a 7-year-old, which doesn't work. And lots of times I think that even us as clinicians, we kind of sit back in our world of theory, and this is how things are supposed to be theoretically, and this is how you make a perfect family, and this is how you do it. And so you just tell your child, you need to talk about your feelings. And every time the child is out of control, you sit down and calm them and say, talk this out with me. That's theory and it's beautiful parenting, but it doesn't always work when the gravel hits the road. So lots of times parents will, in my experience, get frustrated at mental health providers because mental health providers try to make it sound like it's just so easy to do, but they're not the ones that go home with a child that's tantruming for an hour or an hour and a half, and they don't know how to soothe them.
We've talked about a couple potential diagnoses for, is the actual specific diagnosis really does that determine whether or not you believe that there was malicious punishment? Like the specific diagnosis that may or may not have?
No, I mean, I don't think the specific diagnosis. I think in terms of maliciousness, maliciousness for me would mean that somebody would be arbitrarily abusing somebody with the purpose of making things worse for them. I think that when we see the behaviors that were being displayed and some of the behaviors that were happening, that they weren't necessarily being malicious. They were trying to contain and control it in a very inappropriate way.
Yes.
Do you have an opinion
Yes,
as to whether, based on the records that you reviewed, and was a danger to himself and others?
You can approach. We're going to take a 5-minute break. Council needs to review something before we proceed further. All right, go ahead and have the jury retire to the jury room. All right, it's going to be 5 minutes sharp, Ms. Murad. If you don't have what you intend to present to the court, we're moving on. It was disclosed. I'll look at it.
Your Honor, may I state for the record what's in the deposition?
Yes, go ahead.
So, Judge, Dr. Rappa was deposed twice, once on September 20th by the state, a second time on September 27th by the state. The state asked on the bottom of page 11 of the first deposition, I want to just kind of start with what opinion you expect to give in this case. It gets very lengthy, but she states several opinions that she would give. This includes, as he kind of got older and his behaviors got what they thought were more dangerous or more intense in terms of feeling or in terms of hurting other people or hurting themselves, that they, started thinking that we need to manage these behaviors, and the behaviors are so out of control. How can we manage them? And of course, the way they chose to manage them was probably the worst way anyone ever could. Then she said, what else? And that was on page 13, lines 7 through 15, where Dr. Rappa describes sort of at length what her opinion is, and then the state goes specifically. In the second
Is it going too
deposition that
fast
the
for you,
state took,
Reindeer?
I had asked Dr.
Sorry, I
Rappa
was
whether or not
checking
in a
it
clinical
to
setting
see
she
if
makes
her email was
determinations about
on
whether or not a child is a danger to themselves or others.
And it looks like only
Ms.
her phone
Coakley
number
specifically,
is.
and that was on the second deposition taken on September 27th of 2023 by the state, page 35,
And
lines 7 through 15.
thus far,
The state
the
also
motions
asked
are not
Dr.
up
Rappa,
yet.
this was regarding something different that was said in the CPT interview about whether or not is it appropriate to, as a child is using the restroom, sort of have the door open, as there were allegations of that in the CPT interview. And Dr. Rappa said that where there is a danger, that is something that happens in a clinical setting. And that is on page 19 of the September 27th deposition. It's sort of at the end of page 18, all the way to page 19, ending at line 5. As to the oppositional defiant disorder, that is on the September 20th, 2023 deposition, page 38, line 8. Let me just get there. This is the state's questioning of Dr. Rappa. It starts on page 37. I think on page 38, the relevant line numbers would be starting at line 2. Ms. Coakley says, and there's also several other disorders that can share symptoms or overlap or share features, right? Dr. Rappa says, yes. Conduct disorders can. I see you nodding. You just have to say yes. Dr. Rappa responds, yes. The state then asks oppositional defiance disorder, and Dr. Rappa says, yes. And then she lists several other anxiety disorders, social phobias. She lists several other things. So I think in addition to the depositions in the records that the state was provided, has been diagnosed with oppositional defiant disorder and reactive attachment disorder.
Ms. Murad, in any of those, because what you just read doesn't even get close, in my view, of being an opinion being rendered by this witness as to whether she had, based on her review of the records, reached an opinion as to whether ODD was applicable, or based on her review of the records, she had reached an opinion that the child victim was a danger to himself. Just mentioning ODD or being a threat to someone's self is not the same as an expert providing an opinion as to whether that is in fact.
You guys are free to hop between all of us.
That was her conclusion.
I want everyone to get support and love.
Was suffering from ODD or was a danger to himself, as to which the parents had to respond.
I don't have anything additional to what I've already cited on the record, Your Honor. However, I will say that the idea that the state was not on notice or able to explore this in their own deposition, just as we were in our deposition of Wade Myers, I think is not fair.
All right. Well, whether it's fair or not, I'm not going to comment, but both sides know that trial is not the time for dropping new opinions with an expert witness, and I'm not going to permit it in this instance. So I'm going to stay with my original ruling that the questions concerning this witness's opinion on ODD or that the child victim was a potential threat to himself have not been properly disclosed, and therefore they're not going to be permitted to be introduced in this trial. Ms. Murad, anything else you wish to make for the record before I bring the jurors back out? All right, thank you. Mike, you may go ahead and bring the jurors out. And Ms. Murad, you may continue with your direct. All rise. All right, everyone may be seated. Thank you. You may continue, Ms. Murad.
Thank you, Your Honor. When we talk about reactive attachment disorder and complex PTSD, are there behaviors associated with those diagnoses that can become harmful or dangerous to people, to the child or the people around them?
Yes.
Are those behaviors exhibited in this case?
Yes.
Take us through how you've come to that opinion.
Okay, so we know that as early as 2015, some of the symptoms that are being documented for the child include things that are emotional lability, like the temper tantrum, sleep issues, anger and frustration, anxiety and fears. This is, kind of how we pinpoint PTSD in a child, and especially in a very young child, because again, they can't really tell us what's going on. There were also indications in the records where there would be inappropriate behaviors that were hurtful toward other people. And maybe not, maliciously done by the child necessarily when he was young, but so impulsive that, if the thought crossed his mind, he would go ahead and just do whatever it was that he thought about. And it would result in somebody getting injured. There were also, records that suggested that he was doing things that were dangerous in the home. And dangerous to other people that lived in the home. So, and that's not an uncommon thing when you see
Yeah,
children with reactive.
I really dislike this. The more that we've talked about this, I think that the defense should have gone with all of the places that they went to get him help rather than the child as the bad guy. And good morning, Lucy. Thank you for joining us today. It is Friday. The sun was shining, but I think it went back around a cloud again. So we had a moment where it was shining.
Attachment disorder, because those children really do have very active minds. And while they can be very impulsive when they are emotional, they also can be kind of calculated. They can figure out something that they want to do or take apart, or how they can steal something or how they can pull something over on an adult, and then they're able to do that. So you get kind of both of that with a reactive attachment disorder child in it. And these things make them dangerous to themselves many times without them even realizing it, and dangerous to others.
Is there evidence in the record that prior to 2018, there were issues with roaming around the house at night?
Sustained.
Did you rely on records that indicated sort of wandering or eating at night?
Objection, hearsay.
Sustained.
Based on the records that you reviewed, sort of what, do you have any opinions as to why? So you mentioned those behaviors didn't have predictability. Is that fair to say?
Didn't have what? I'm sorry.
Predictability.
Yes, I agree
Why
too.
is that concerning for a parent?
When you have behaviors that aren't predictable, and the child is trying to kind of outsmart you or get one over on you, you're not quite sure what's coming next. So sometimes what's coming next is something that can be pretty dangerous.
Sustained. Answer. The last part of the answer is stricken. Jury is instructed to disregard it.
Is there evidence in the record, as you just stated, that one was exhibiting dangerous behaviors?
Sustained.
I want to talk about a particular, admitted in his trial testimony that you've reviewed in coming to your opinions, correct?
Yes.
That there was a search that he made on his school laptop for something very violent. Are you aware of what the substance of that search was?
Yes.
What was it?
Sustained.
What is, can you explain to us how the searches that people make, like why is that relevant in determining anything about someone's, whether or not that person is a danger?
When you're looking at
Don't look at my searches with true crime stuff that I do all the time for trials, because oh my goodness.
Approach.
I mean, I'm not trying to be a smart aleck, but honestly, I look up the strangest things for this channel just to, see if what they say can happen happened. I often wonder at what point behaviors impacted the giver's permission base. I can't imagine them putting their newborn in such an environment. Their permission base changed. I'm curious. I don't know. I wonder. Oh my god. Yeah, seriously. Please don't search my history. The what I wonder is if they quite naively, quite pie in the sky, thought that they could make up for the early childhood neglect, um, that he experienced at the they would just love the heck out of him and he wouldn't have any problems. And I'm sure that they were made aware, by international adoption agencies that he was probably going to come with these problems, or at least, you know, they probably had an inkling as they started getting into this that he was going to have some severe problems with the scabies and things like that and getting into it. And maybe naively at the beginning, they thought that they could just love him through it. And their first daughter seems to be a very I don't know if you all were around at the time that birth order was really a big thing in psychology. So, you had a like big, firstborn, I'm a firstborn and I'm a middle child. And then, your place in the birth order really explains a lot of your personality. That was really big when I was a child. So I wanna say early '90s is a big part of when that birth order kind of psychology was really big, and my mom would read this book all the time, like or these birth order books and try to parent us, according to birth order a little bit, and I was what was considered a compliant firstborn. So their first, born adoptive daughter seems to be very compliant, very, attentive to rules, very, grounded, very easy child to parent comparatively. So I think they were thrown a curveball. And I don't know if maybe this child just blindsided them and then they had started having their own children and they just got overwhelmed or what. I don't know. I don't know if they just naively believed that loving him would fix everything that had happened in his early childhood. Um, and when that didn't work, they like this professional said, they would go to one, psychologist that would say, "Okay, let's sit down and talk about your feelings." And that's really good until, you have a child that is throwing a fit for an hour and a half because he has to do a 5-minute timeout, and you have to sit there and, continue to establish the ground rules of you did the time or you did the crime, you have to do the 5-minute timeout. These are the, consequences of your action, you know, and that therapist isn't there to kind of have to put those rules into enforcement. And, when the rubber met the road, I don't know if they just got overwhelmed or what, but something went terribly wrong. I don't know what. Who knows? But yes, I am a compliant firstborn, if you would like to know. I don't like to create waves. I am not confrontational person, um, which is why the turtle boy thing is completely out of my realm of understanding. So while, you know, Dave has to understand the legalities of it, it is something that is way beyond my personality comfort zone. I could never even halfway understand how one would do that because that kind of confrontational attitude is, um, much beyond me.
All right, objection sustained. Ms. Murad, you may continue.
Oh,
Is it your opinion
I'd love to be
that
forgotten.
the Ferreters
I'm the
were
one that
responding
is
to his
expected to
behavior?
do everything well and be an example.
I'm going to overrule in part, sustained in part. You can answer it, but it has to be solely with reference to what you observed and reviewed in the records that you reviewed in connection with your opinions as an expert in this matter.
You ask again?
Sure. Is it your opinion that the Ferreters were responding to his behavior?
Yes.
And is that behavior indicative of early childhood trauma?
Yes.
Do we see Ronan's behaviors or the ones that the Ferreters were responding to prior to May of 2018?
Sustained.
Did you rely on records in coming to your opinion before 2018?
Yes.
No further questions.
All right, Cross, Ms. Coakley.
Good morning.
So you were hired by the defense in this case,
Yes.
and you charged them a fee. What was your fee in this case?
I charge $350 an hour. As of today, I have made $5,000.
And then there'll be an additional amount for testimony today,
That is correct.
preparation for this type of thing, correct?
Yes.
Now, today your work is mostly in the courts,
Correct. 100%.
right? And mostly criminal cases, correct?
Not necessarily. I do a lot of civil cases also.
But as a court psychologist or a forensic psychologist, that means that you do things like competency evaluations for the
Not-
court.
No, ma'am, I don't do very many competency evaluations. I'm not on the wheel or get appointed by the court for that. Occasionally, I might do one for a criminal attorney, but it's very rare.
You do insanity evaluations
I do.
sometimes,
Yes.
whether or not someone was sane at the time of the trial.
Yes,
You do risk assessments for sex offenders.
I do.
You do assessments for criminal defendants in general to make a determination for things like sentencing
Yes,
to
I do.
advise the court. You haven't been involved in any publications related to childhood trauma, attachment disorders, or bizarre punishment, correct?
I have not.
And you don't do peer review for that type of stuff or scholarly journals.
I do not.
And while over the course of your career you have treated patients, you don't treat reactive attachment disorder.
I don't. I treat early childhood trauma. I have no issue with that. But once it gets into persistent reactive attachment disorder, no, I would refer that out.
You would send it to another professional in the field.
I would.
And while you have testified as an expert in court on a lot of different topics, a lot of different psychological issues, you've never testified in court before on a case involving extreme, bizarre, or malicious punishment, correct?
Yes, I believe that's true.
So this is the first one.
Yes.
Now, I want to talk about the items that you reviewed in this case. You did not speak to the defendants, correct?
That's correct.
And so your assertions about what they intended or what they thought or what they were trying to do, that's not based on any direct information that you have, correct?
That's right.
You don't actually know for sure what they were acting on or what. they were
Gosh, this defense
No, I
attorney's
have not
Kate
spoken to
or
them, so I would not know
her
their intent.
And you didn't actually speak to
tone
anyone in the
is
case.
just-
You reviewed the records similar to Dr. Myers.
Yes.
I mean, she's asking good questions.
And when I
but
say
her
that you reviewed the
tone is
records, there's
just-
records from some prior practitioners. You didn't speak to them either, correct?
I did not.
Now, I want to talk about your opinion. You can't give a diagnosis in this case, correct?
I would feel very uncomfortable giving a diagnosis without interviewing someone.
Okay. And so part of that is that you have insufficient information to make a definitive diagnosis, correct?
Right, because I'm missing that interview portion.
But you do have an opinion on whether or not the defendant's actions were an appropriate way to manage the behaviors in this case, correct?
Yes.
It is your opinion that the way that they chose to manage the behaviors is probably the worst way anyone could ever manage these type of behaviors, correct?
That's correct.
Now, although you can't make a diagnosis, you think that there are indications that the child in this case has complex PTSD as well as an attachment disorder, right?
Yes.
And if a child does have an attachment disorder or complex PTSD, the way the defendant acted towards the victim is the complete opposite of what anyone should have done with a child with one of those conditions, correct?
Yes, ma'am.
In fact, confining and isolating a child can exacerbate those disorders, correct?
That's right.
And so exacerbate means make those symptoms worse,
Yes.
correct? Even in a child that doesn't have PTSD or an attachment disorder, this type of treatment of any child creates a risk of harm to that child, correct?
I agree.
To both the mental and physical health of a child, correct?
Yes.
So there is a reasonable likelihood that of psychological harm to a child that is treated this way, even if that child does not have any underlying issues.
I agree.
Isolation is not something
Yes, I
that is
saw
used.
that. So what I might do is get to the end of this particular expert. We will then go, we'll see what they have next. I think this expert is on for a bit longer because the cross is quite in depth. Sorry, I was covering my mouth. I thought I was going to sneeze, but then I didn't. And then I believe they play videos. We'll see if what those are. And then I think they have closing statements or closing arguments. But I wasn't going to sit here for all of the video. What I was gonna do is do closing arguments after this witness, and then we would go to the, hearing yesterday, because I'm making this the last day. I think we have said all we can say about this. And I don't know that he made a decision. But what I did say, and I don't know if you were here, Lucy, is I am going to try to find an email for Dr. Sheila Rappa and see if she can. I know she's probably very, very busy. Oh, okay. Yeah. All right. Then if that's only audio, I'm not sitting through that kind of torture again. Uh, and see if we've heard a lot of what not to do, but these are very stressful times. We've got a lot of economic pressures and things like that, and kids, dealing with social pressures and other things. This, I really like this expert, and perhaps, I know she's super busy, but if I can find an email for her, she might not have time or the inclination to come onto a YouTube channel and talk to me, but if she can give us maybe resources online that parents can look at, if their kids have, oppositional defiance, if they are just, at the end of their rope, certain resources that she recommends to look at, you know, things, wisdom. Again, she might be super busy. She might not even respond to me, but you miss 100% of the shots you don't take. So if I can find an email for her this weekend, I will shoot that email out and see if she can give us some resources to look at. And then I will share those with you because I really like this therapist. And I think that's one of the most bittersweet things about this case is that had the Fairders, found a therapist like her early on, I think that all of this could have been avoided. I think that, this family could have been broken. Yes. Or not been broken like that. And yeah, I don't know that I'm going to cover Tracy's case as quickly. I might just do opening statements and then hopefully she'll take a plea deal because, oh Lord, could we save ourselves this again?
Used for children, correct?
It should not be. People
Right.
do, but it should not be.
Right. It's not recommended.
That's correct.
It's not considered acceptable within the psychological, within the child abuse community, really within normal community, correct?
Yes.
Now, I want to talk about some of the records specifically that you reviewed. You reviewed some emails from Immaculate Heart, correct?
I did.
That is where the child in this case went to elementary school, correct?
Yes.
So he's in 4th, 5th grade when he's at Immaculate Heart, correct?
Yes.
If we do the math, that means he's about 10 and 11 years old during that time frame, correct?
That would be right.
So you reviewed an email from February 13th, 2018, which was one of the things that the parents got notified of, a behavioral problem by their son, correct?
I'm not, without having it in front of me.
Sure,
I'm
I
not
can
sure,
get it if you
yes.
look. But there was one of those emails was about because he was using a bad word, correct?
That's correct.
That's one of the things that they got contacted about, correct?
Yes, he used the F word.
Right. And he said that using bad words makes him feel bigger, that he can be protected from the bigger kids.
Yes.
He uses bad words, correct?
He did.
He's 10 years old at that time, correct?
That's right.
On February 28, 2018, he punched a kid, correct?
Yes.
And that was in response to getting kicked, correct?
That's what he said. Yes.
That was information provided to the parents, correct? 10 years old still at that time, correct?
Yes.
On May 15, 2018, we had that incident where he pushes another child against the wall with his fingers on the child's throat, correct?
Yes.
And
If it's
the
a stink
teacher
bug,
concluded
get that
in
bug
case
away
that
from
both
them. My
children were not
cats
saying nice things to each other in that incident, correct? That kind of proceeded.
That's what she wrote. Yes.
Right.
loves to
And
eat
at that
stink
point,
bugs,
the child in this case is 10 years old also, right?
Yes.
and they
There's
stink.
October 29, 2018. That email is about roughhousing during a game. That's how
Yes.
the teacher put it, that he was roughhousing, right?
Yes.
December 3rd, 2018, they also got contacted, and it's because he stole a piece of candy off his teacher's desk.
Yes.
January 29th, 2019, he kicked a ball at a student, correct?
Yes.
And he got punished by the school by sitting out of recess and writing a letter of apology.
Yes.
And February 2019, they also got contact because he stole a container of sprinkles.
Correct.
He's 11 years old when he stole the sprinkles from school.
I would say so, yes.
February 2019,
Yes.
10 or 11. February 2019 is when there was a mutual physical altercation with another student,
Yes,
where they get in a fist fight, the little boys, and they're both punished. They both get detention.
yes,
And March 8th of 2019, that's when there the technology issue, and he was found with a calculator, right?
yes, he had stolen a calculator, correct?
And then March 22nd, 2019, he embarrasses his sister in class, correct?
Yes,
And that's about a month after his brother is born,
yes,
when we know based on the timeline that he's already living in the garage that they built for him in Arizona, correct?
yes, he would be by then,
A fifth grader, 11 years old.
correct?
And then March 27, 2019, he uses inappropriate language again. He says another bad word.
Yes,
So between 2018 and 2019, at the elementary school, there's 2 incidents that involve physical contact with another child. The fighting incident and the pushing against the wall.
Yes,
For the large part, every other behavioral incident was something like saying a bad word or stealing a piece of candy or stealing another item.
yes, that's correct. It's stealing or the candy, and then the humiliation of his sister, which I think was on a whole different level.
He got up in front of the class and he made her cry in class.
I mean, I think that if you look at it that way, it looks, kind of simple. He got up in front of the class and made fun of his sister or said some things,
But that, I
really-
mean, that's what occurred, right? My question is, that's actually the action that occurred, right? He's in the 5th grade, 11 years old, and he says something mean in front of the class about his sister, correct?
that is what happened.
Now, I want to talk for a second about that neuropsychological exam that we discussed. And that neuropsychological exam happened in October of 2022.
Yes,
So on the timeline, this occurred after.
Y'all, am I a terrible person that I hope if I actually do cover the Tiffany trial that they put another prosecutor on that doesn't have her frequency or her tone? Oh my goodness.
the defendants were arrested and were charged with child abuse, correct?
that's right.
They did not have any of that information about the neuropsychological exam prior, correct? As far as you know.
Yes, correct.
And there's no indication from the record you reviewed that the defendants ever sought a neuropsychological evaluation prior to being arrested for child abuse, correct?
That's right.
And there is background information, I think you talked about it with the defense, that is self-reported, correct?
Yes,
That means that there is information that the child provided, and then there's also information that Ms. Ferreter provided, correct?
yes,
And because of that, the report includes a limiting instruction or a cautionary instruction, correct?
yes, all reports would.
And that information was provided after Tracy Ferreter had already been charged and arrested with the abuse of her child, correct?
Oh no.
And the report itself contains a caveat that because it in part relies on self-reported information, it is limited in extent, correct?
Yes,
It's highly subjective,
yes,
correct? And it may contain errors of interpretation, correct?
yes,
And also omissions.
yes. It's people are giving you their own perspective of the situation.
And you talked about those neuropsychological results, and there was in part some difficulties in executive function and impulse control, correct? Right? That was 2 of the things that report found, correct?
Yes,
And both of those things can be the result of trauma, correct?
yes,
And ongoing abuse throughout a child's childhood could make issues with executive functioning worse.
absolutely.
It also could make, if there's ongoing abuse throughout childhood, it can make issues with impulse control worse, correct?
Yes,
Oh, not a stink bug.
Anytime you take a child who has
Okay, so Eris, what my husband does, because we have, I don't know, I love that I'm using any excuse to not talk about this trial anymore. I am so sorry. He takes if you have an empty water bottle or pop bottle, trap the bug inside that, put the lid on, and then take it outside. If the cat happens to eat it, like has happened a bajillion times, Fry has not yet perfected it, because apparently barking at said stink bug does not make it want to jump into your mouth hole, oddly enough, as a stealthy hunter. It produces a giant smell. And then he takes it outside very quickly.
an
we've
early childhood
learned
abuse
this.
or neglect, and then you add to that, it's going to exacerbate any symptoms that they have, correct?
yes,
So if you take a child that has early childhood neglect or an adverse childhood experience, right? Like in the orphanage, that would be an example of an adverse childhood experience, typically, correct? If you take a child like that and then you subject them to additional ongoing abuse, that might exacerbate their symptoms, correct?
for sure.
Now, the report that we're talking about also talked about that the victim in this case had some difficulties in executive functioning, correct?
Yes,
And the way in which he was treated has a risk of increasing those difficulties, correct?
Yes.
He also had, you called it some difficulties in self-monitoring. The way that he was treated would increase the difficulties in self-monitoring, correct?
Sure.
You also mentioned that it was determined that there's some difficulties with emotional regulation, correct?
Yes.
The way that he was treated would increase his difficulties with emotional regulation, correct?
Yes.
Now, a child that has these characteristics that you said that were clinically significant, it is never an appropriate treatment for those types of clinically significant difficulties, the way he was treated to confine him.
Yes, you're right.
Hello.
You also
Blue Hair
noted that
Bible
there was some
lady.
difficulties in impulse.
Why isn't the defense objecting asked and answered? I mean, I believe we've established that this was exactly the wrong punishment, but now you're allowing the jury to hear this over and over again. And while I agree that this was a terrible punishment, no good, very bad parenting, I mean, you're still allowing the juror to hear this shrill lady ask this again and again. And look, this prosecutor's doing a great job. She is doing her job well, but she is shrill. At least in my opinion, and it could be that it's just a Friday, but still, she's shrill.
Control, but confinement is never an appropriate treatment for those difficulties either, is it?
That's correct.
And this report that occurred in 2022, it actually didn't come to the conclusion that he had reactive attachment disorder.
No, I believe he gave him an impulse control disorder.
And these types of difficulties that you talked about, difficulties in impulse control and executive functioning, they're not actually part of the diagnostic criteria for reactive attachment disorder.
That's right.
Right? Individuals who do not have reactive attachment disorder can get these same results.
Sure. I mean, if they have a disorder of impulse, they can get it just because of that.
And these are areas of the brain that you also see impacted by someone who has PTSD.
Yes.
Now, want to talk about
If Mr. Mo asks, that's why I bought 2 pairs of boots at the mall yesterday. Also, they were on buy one, get one half off.
additional thing you reviewed. You said one of the things that you reviewed was the deposition. And I think it noted that the deposition was 5 hours long.
Yes, it was long.
That's a long time for any person, never mind a child, correct?
Yes.
And it's sometimes people, when discussing things, even traumatic things, respond in a way that is not necessarily considered normative or appropriate, correct? Sometimes people laugh inappropriately.
Sure.
Now, I want to talk about—
Y'all, that is my go-to. I feel terrible, but when bad things happen, I either turn into like, down to business, I shut off all emotion, or I giggle inappropriately, which is a horrifying thing to do at bad times.
reactive attachment disorder more specifically. So reactive attachment disorder is a diagnosis that's in the diagnostic. Tell me what it's called, the DSM. What does it stand for?
DSM-5, the Diagnostic and Statistical Manual.
And so that is the manual that psychiatrists and psychologists use that sets out the standard diagnostic criteria for a lot of psychological and psychiatric conditions.
That's true.
Also has some behavior disorders and personality disorders, lots of different things, but it's a standardized way in which we evaluate if someone meets those criteria, correct?
That's right.
And you couldn't formally make the diagnosis in this case of reactive attachment disorder.
I did not know.
But your opinion that there is some reactive or there's some attachment disorder characteristics here is based on the review of records of other people, correct?
Yes.
You don't know the methodology that any of the other people who looked at him relied upon, correct?
Yes, I don't know specifically. I know if they're licensed, then they would have to abide by, whatever their professional
Oh,
license
well,
is
good.
and the DSM.
Thank you,
to make a
WW. I
diagnosis.
don't feel
But the reports that
terrible
we
now.
have don't go into the underpinnings of their diagnosis, correct?
No, you wouldn't necessarily get that from anyone exactly how they got to their diagnosis, but you would assume if they're licensed that they have taken tests and been educated and supervised and know how to diagnose appropriately.
One of those people that made a diagnosis is a Mr. Kenny Miller, correct?
That's correct.
He is actually a licensed clinical social worker, correct?
Yes, he is.
So that's a
Oh,
master's
good.
level practitioner, right?
Yes, he is.
Not someone who has a doctorate like yourself or Dr. Myers.
Correct. But I will say that some of the best clinicians I've ever met in my life are licensed clinical social workers. So just because they have a master's degree as opposed to a doctorate doesn't necessarily make them a lesser clinician.
You actually, though, don't have any of Mr. Miller's clinical notes, correct?
I do not. Only what what I was given, which I believe was a letter talking about when he had talked to the Fairders and when he had seen them.
Okay, so you don't have any of the treatment progress notes that were contemporaneous to when he was treating in this case, correct?
Yes, I do not.
The only thing you have is a letter that he wrote after the defendants were arrested, correct?
Yes,
And the letter doesn't explain the diagnostic criteria, correct?
not at all.
It doesn't indicate if he even met with the child. It's kind of vague as to whether or not he did.
I think he said he met with the child.
Right, but it's unclear once, twice, beyond that.
Right. That was hard to determine how many times he had met with the child, how many times he'd met with the parents. But he did say they had ongoing communication.
And if he did in fact meet with them, the time frame that we're talking about is after the child, the victim in this case, was 10 years old, correct?
That would be right.
I'm glad I have
And you're familiar
confirmation.
with the DSM and the criteria that they have for reactive attachment disorder, correct?
Yes.
That manual also provides some cautionary instructions that practitioners should take into consideration when reaching a diagnosis, correct?
That's true.
And some of those cautionary instructions as it
Okay,
applies to
so
reactive
this prosecutor is also forgetting that on these psychosocial, neurosocial tests where it asks you to put in, your own thoughts, these tests where the person has to fill out their own thoughts. If you remember from the Letitia Stalk case, these have validity tests baked into them. So again, if the person is trying to say malinger like Letitia was, thinking she's crazy AF and she scored off the chart for malingering, or as she explained earlier in her testimony, say the parent is trying to claim their child is an angel with wings, it's going to show up there in those baked in validity tests regardless. Now, I know the prosecutor is, putting her own spin on, which is what you're allowed to do in trial. But just for, context, these tests do have baked in validity scales, which you can go back in and say, hey, this person spiked kind of high for putting themselves in a I'm perfect, I don't have any problems sort of, metric. So we might want to dig into that a little bit. Or this person spiked really high for, I am pretending to be crazy because I want to be found as incompetent to stand trial. So these are forensic tests that one would get for like Letitia, like when she was trying to pretend she was crazy.
attachment disorder is that it shouldn't be diagnosed after the age of 5, or if it's done, it should be done with extreme caution.
I agree with
Correct?
that.
That's what the DSM says.
Yes.
And based on the very limited information we have from Mr. Miller, we don't know why he is making that diagnosis after 5 years old, correct?
Right. I'm not sure why. I'm assuming that he would make a diagnosis the way anybody that is licensed would make a diagnosis.
And then you also review the records of a Dr. Reichenbacher, if I'm
Yes.
saying that correctly. And Mr. Reichenbacher is a psychiatrist.
Correct.
And he, you
Well-
have some of his treatment notes from his meetings with the family and the child, correct?
Yes,
He notes reactive attachment disorder and ADHD, correct?
he does.
But he has no indication of the appropriateness of
Didn't
whether or
she
not
just have a movie
why he's
come
making
out
that
too?
diagnosis after 5 years old, correct?
Right. I don't
Something
think
like
we would
Into the
normally see in
Fire or
somebody's,
Death by
treatment summary
Fire,
how
something
they
or other.
arrived at that diagnosis. You would see the diagnosis that they rendered, and you would assume that it was because they had records available or interview available. However, they made the diagnosis. But we would assume if somebody is
Yikes.
licensed, that they're
Well,
giving a
I'm glad that you
diagnosis
made
based
it out
on
of brain
their,
surgery. I have a
professionalism
very
and
dear
their knowledge.
cousin who
And so you're making some assumptions
had
about what
that
they're relying
too,
upon
and
because we don't have any
I don't know
additional
that
information, correct?
she
Right,
had
but
to
there are
do those
standards and rules of
tests,
how we
but she
diagnose somebody.
and
So it would be very rare indeed for somebody to be
she
diagnosing out of the
survived,
blue
and
with
we
no
didn't know if she
information
would,
whatsoever.
and that was a
Now,
really
in
scary
looking
time.
at Dr. Reichenbacher's notes, there's no indication of whether
Yeah,
or
I
not
think it
in
did
making
like
his
23,000
diagnosis, that
worldwide,
he was aware that during this time frame,
which, hey,
the
is the
victim is being
price of a
confined in a structure
a
his
used
parent-
car
his parents
now,
built in the
so
garage, correct?
Right, that is not in his notes.
There's no indication that he was aware of that, correct?
Correct.
And that would be important information for a psychiatrist to have in making a differential
but I don't know if
diagnosis.
Amber is
I
used
think
to
so. I would
living
have
the
liked to have that
used car
information.
life anymore.
Now, Dr. Reichenbacher saw between December 2018 and January 2019, correct?
Yes,
And so the last time we have of him being involved in all was January of 2019, correct?
yes,
Which is 2 years prior to the arrest in this case.
yes,
Now, there's a handful of meetings, 3-4 meetings total, correct?
that's right.
And the meetings, aside from the initial assessment, are about 20 minutes long.
Yes,
And the victim in this case is 11 years old at the time.
yes,
And so in December 2018, they have their initial evaluation, correct?
Yes,
And the recommendation is that perhaps the victim in this case may need behavioral therapy.
correct.
And then in May 7th of 2019 is the next meeting,
Yes.
correct? And it's noted from the report that the parents reported to their psychiatrist that they were seeing for the behavioral problems of their child, that he is not having severe aggressive behavior at school. That's what the parents report, correct?
Yes,
And they also noted adequate behavior at school regarding focus and hyperactive behavior, correct?
yes, he had been placed on medication at that time.
And then the doctor decided at that point that the treatment going forward would be to continue medication and therapy, correct?
Yes.
But there was a problem because the parents were going to go away for the summer, so they might not be able to get that therapy.
I don't remember why they didn't, but they didn't get the therapy at that time.
Now, in January 23rd, 2019, they also went back to Dr. Reichenberger, correct?
Yes,
And the chief complaint that his parents brought was that he has some anger, correct?
yes,
And the mom reported some improvements in his ability to not get angry or apologize and later on, correct?
yes.
And the child got tearful when his mom was talking about him, correct?
That's what the report said, yes.
And they reported that he had not been seeing a therapist at that point. And the doctor, again, recommended that they should do medication and meet with a therapist, correct?
Correct.
At no point did Dr. Reichenbacher recommend confinement
Never.
to the parents. And at no point did the parents report that there was issues with the child hurting animals, correct?
To that
To
doctor?
Dr. Reichenbacher.
Right, to that
No.
doctor, no.
And I think that you mentioned that that was something that may have existed in this case, but isn't it true that the only issue that he ever had with an animal is when he overfed a dog?
No, he had been riding a bicycle and was riding the bicycle into the dog.
Okay, so he hit the dog with a bicycle.
Yes,
And you know that in 2022, in January, at the time that we're talking about from reviewing the videos, that there were times where the child is allowed to be alone with the dog.
no, I didn't.
You didn't see that? There's
I
times
did
he-
see him out with the dog, but the family was around.
Okay. Did you see any of the videos where he's alone with one of the dogs in the room in his structure in the garage, locked in the room, and the dog's in there?
Oh, I didn't recall that.
No. Okay. And there's other times that family had multiple pets where he's allowed to be around with the pets.
Yes,
Correct.
I mean, I definitely saw him with the family with the pets.
Now, going back to reactive attachment disorder, social and the diagnostic criteria, social neglect is a necessary condition, meaning that there has to be a time in early childhood where their child was subject to extreme neglect, correct?
That's right.
But it doesn't necessarily mean that just because that occurred that a child is going to have reactive attachment disorder, correct?
That's right.
And when a person has reactive attachment disorder, there's actually two types, correct?
Yes, it's been divided into two types.
There's one where the child is overly affectionate, almost indiscriminate with their affections towards adults.
Yes,
That does not seem to be the case here. There's no indication of that.
no,
So that's not what we're talking about here.
correct.
The other one is when the child has difficulty forming attachment, correct?
Yes,
And there's nothing in the criteria or what we're looking at in diagnosing it that has anything to do with violence.
no, it's only if the child will refuse to be comforted by a caretaker or will not go to the caretaker to be comforted. So it's very specific.
Okay, so you saw a lot of signs to see a child that appears withdrawn or unable to be comforted by an adult.
They're not necessarily withdrawn, but they're unable to be comforted. So they're having intense temper outbursts, and the parent goes to comfort them, and they don't want that. It makes it worse, actually. Or the child hurts himself or is out of control emotionally and won't go to that parent for soothing. So it's a very disturbed way of attaching.
Right, but there's nothing in the criteria that says that the child has to react towards herself or others in a way that involves violence.
No, I mean, not necessarily. But when you look at it and when you look at reactive attachment disorder as it is studied, these are the behaviors that are seen in the studies when people are diagnosed with this.
Now, when people are diagnosed, the DSM tells
One thing I do love is when lawyers try to tell experts how things are done, and then the expert's like, that's not exactly how it's done. And the lawyer's like, okay, well, I'll move on.
us to, and I think you've already agreed that after 5, it should be done with extreme caution. And that's in part because it is unclear if reactive attachment disorder even occurs after the age of 5, correct?
Sure. So what happens is many people, some people are in the camp that, you can have persistent reactive attachment disorder that goes through middle childhood, through adolescence, into adulthood. Some people are of the camp that, hey, it's reactive attachment disorder, but really what's underlying it is that complex PTSD. And that's why we see it continue throughout the lifespan. So it really just depends on what camp you're in. There's a little bit of research for both.
Now,
And
according
I
to
am
the
such a
DSM,
nerd. This
the
love,
reactive
I
attachment disorder is
love
incredibly
when
rare,
she
correct?
gets into the deep,
it's not
like,
something that you would
this
see
is what
often
some
in your
people
practice.
believe in.
And you're familiar, and it's something that is considered that has a high risk of misdiagnosis, correct?
I think that it did back in the day when people were first hearing about it and calling everything that a child did rad, everything was rad. I think now clinicians are way more cautious about diagnosing, but when you see somebody like Ronan that has that really severe neglect, malnutrition, scabies, I don't think that it's a leap. I think it makes sense and based on his behavior.
Well, you're a member of the American Professional Society on the Abuse of Children, correct?
I am a member, yes.
And it goes by the acronym ABSAC.
That's right.
And as a member, you stay up to date on the professional recommendations and also ABSAC's positions on the latest research and community standards for the treatment and for child abuse, correct?
Correct.
And ABSAC, the task force, issued a report on attachment disorders and attachment problems, correct?
They did.
And the report points out that that reactive attachment disorder is actually incredibly rare, correct?
I agree with that.
And they also point out it's also known that there is an inappropriately high number of children misdiagnosed with those, especially those who have only a mild or moderate.
So what she's saying is that given the fact that the child was in a high baby to low caregiver orphanage, we don't know what happened in the 7 months that he was with his mother before he was left on the orphanage doorstep. We know that he was infected with scabies at either the orphanage or either when he was dropped off with the mother. I'm not quite sure where the scabies lined up, but he did have them. That there is a pattern of severe neglect in early childhood that while there might have been an early leap in the beginning, I believe scabies are lice. Let me check real quick. Because I think they are, but let me check. Okay, it's a burrowing mite, contagious, intensely itchy skin condition caused by a tiny burrowing mite. Scabies is contagious and spreads quickly through close physical contact in family, school, or nursing home. So if you imagine this tiny infant either in a orphanage or, being dropped off at the step of an orphanage, with these burrowing mites that are intensely itchy that the baby can do nothing about, you have maybe 1 or 2 caregivers for a giant amount of babies that, they can't give them as much care as they need. This doctor said that they were giving them sugar water. There wasn't enough food to go around, I guess, in this orphanage all the time. So while, when it was first, thought up as a diagnosis, reactive attachment disorder was maybe overdiagnosed. In her opinion, reactive attachment disorder is not a frivolous or a leap of the imagination with this child because of her expertise, all of the criteria that she has because of her background. What I do like is that the prosecution has done their research, has, taken her background, again, anticipating that the defense is going to use this and, said, hey, this has been, a catch-all diagnosis for a while, but this doctor is saying, look, I understand that this has been a catch-all diagnosis for a while, and I thoroughly admit that people have, overused it. But in my clinical opinion, with all of these, particular things that I have seen, and because I am a part of this, while it was trendy to do all of this before, I disagree, and I think that he does have this, and I'm willing to stand behind this. So it does give the jury at least, a greater sense that this professional is willing to stand behind this and kind of steel sharpens steel. So this expert is having to defend her ideas, and she's doing it in a way that is very professional, but it's also very, it's taking the facts and it's letting you know her thought process, and it's explaining it very well with the facts in this case. But I also like that the prosecutor, despite her tone of voice, has done her research and is citing things in this particular expert's background that, are making these things relevant.
For its symptoms, correct?
Yes.
And the report points out that, and I think you already discussed, that there is incredibly abusive ways in which sometimes reactive attachment disorder gets treated.
Yes.
That includes extreme control over every action that the child has, correct? In extreme circumstances.
Yes, it's parents that are desperate parents trying to control these behaviors, and they're controlling these behaviors in ways that are detrimental to the child.
That are harmful.
Yes.
Blue hair,
And the report points
I
out.
do have most of this case. I will make a playlist. You can watch it. I will say I am not going to watch the videos associated with the defense. It's they are just going to show the audio. I'm going to go straight to closing statements, and then we will watch the oh gosh, what is it? The hearing that was yesterday. The verdict came. We started out behind on this case, and then I got more behind. So we are watching from the past.
That one of the key things for treating reactive attachment disorder, or ways in which it is recommended in general to be treated, is it focuses on actually the actions of the parent as opposed to the child.
That's correct.
The most effective therapies actually don't rely upon the child, correct?
It's mostly teaching the parent how to parent that type of child, because parents think, especially foster parents or adoptive parents, think that love is enough. And if they just lavish this child with love, this child's going to get better. And it's very frustrating for that parent when they're trying to do all they can and the child is not changing or getting worse.
Now, I want to talk about hoarding food. Hoarding, stealing food is something that you see commonly in children that have a history of deprivation or come from deprived or neglected backgrounds, correct?
That's right.
And the way in which to deal with that behavior is not to limit access to the food.
It depends. Now, there are some, there actually are many foster parents that put locks on their refrigerator because during the night the kids will get up and they'll eat every single thing. So I think that there is a way to therapeutically put some limits, but to take food away from child or not let them have food, that's totally inappropriate.
Now, let's talk about PTSD. You said that it's your opinion that there is complex PTSD here that occurs
Yes.
in early childhood, correct?
Yes,
The DSM also sets criteria for
Same.
post-traumatic stress disorder, correct?
it does.
And it has a separate criteria for children that are over 6 and children that are under 6, correct?
Yes.
And the first thing in order to be diagnosed with PTSD is you have to directly experience a traumatic event, correct?
That's right.
And it gives examples of traumatic events, but there are things like actual threat of physical violence, death, bodily harm, correct?
Sure.
It doesn't talk about lack of food or being in an orphanage. There has to be an actual physical violence experienced by the child, correct?
No, I totally disagree with that. I don't think that the DSM-5 could list all the different types of trauma. And I think severe neglect absolutely would be part of severe trauma for children. Also, you say bodily injury. Starving a child and giving them sugar water is bodily injury. So yes, these children are experiencing trauma and they're experiencing bodily injury. They're just not old enough to talk about it.
So the DSM says exposure to actual or threatened death, serious injury, or sexual violence in one or more of the following ways: directly experiencing the traumatic events, right?
Correct.
Witnessing in person the events as it occurred to others, especially primary caregivers,
Right.
correct? Or learning that the traumatic events occurred to a parent or caregiver, correct? Those are the three things that they have to directly experience, correct?
It could be either one of those.
It could
but
be any of
yes,
those three, and the
in his case,
alternative.
he had directly experienced it.
Now, you also said that it can occur in infanthood, but the DSM says that PTSD can occur beginning only after the first year of life, correct?
You would wait till they were like 9 months old before you would diagnose that. But again, it would be diagnosed not through the DSM if they are a young child. It would be diagnosed through the diagnostic classification 0 through 3, which is a whole different book.
But the DSM, right, the Diagnostic and Statistical Manual of Mental Disorders, said.
Okay, lawyer lady, you are arguing with an expert. Do you see? Okay, I did an unfortunate pause, but she is trying to explainarate to you that young children use an entirely different book. But I'm sure you're going to continue to explain to her how to diagnose children.
As
Go ahead.
that it's occurring after the first year of life, correct?
Right.
For PTSD.
I mean, that's what they say. And you're not going to necessarily diagnose PTSD until a child is a little bit older, because you would have to see You would have to see emotional lability. You would have to see that child having difficulty sleeping. There'd have to be some symptoms that you're seeing that wouldn't be attributable to that child just being a newborn.
So in complex PTSD, you see interpersonal trauma, and these traumas have caused them to experience fear, horror, anxiety to the point where they now have developed a disorder, correct? That's how you would describe it.
Yes.
And symptoms that you may see in a child that has, or a person that has PTSD are emotional reactivity, correct? Emotional numbing, correct?
Yes.
Lack of trust
Yes.
and avoidance, correct?
Correct.
And there are treatments for PTSD even for young children.
There are.
And there is trauma-focused cognitive behavioral therapy, correct?
You can start that as early as age 3.
Some people do EMDR with
They do.
children.
Yes.
And the focus is not on the behaviors when treating PTSD, but what's underlying those behaviors in terms of abuse and neglect, correct?
Exactly.
It would not be appropriate to confine a child to a room with PTSD as was done in this case, correct?
Correct.
That would never be appropriate, correct?
Correct.
Reacting to a child who has complex PTSD or an attachment disorder with things like anger and threats is not productive or helpful to a child with those conditions, correct?
Right.
And those reactions create a psychological harm to the child, correct?
Yes, and it can exacerbate problems that were already there for
A-
sure.
adding to the existing harm,
Yeah.
making it worse. I see you nodding. We just have to say
Yes.
out loud, yes. So PTSD can be worsened by ongoing abuse and neglect, correct?
Yes.
In fact, you would agree that there would have been damage done to the victim's neuropsychological health from the defendant's actions in this case, correct?
Yes, most likely.
It's your opinion that the way that his parents handled the symptoms from PTSD exacerbated it, correct?
I do believe that.
And this is not a way that a child with early childhood neglect should be parented, correct?
That's right.
Not only was it harmful, but none of the ways in which they addressed him or he was treated would be useful as constructive punishment, correct?
Right. No.
Now, I think that you also said when we spoke previously that there were some indicators that the child was experiencing some symptoms of depression prior to the removal from his parents.
Sustained. Next question.
Let's talk about abuse and neglect generally. Over the course of your career, have you come across cases where there was ongoing abuse and neglect, but the abuse and neglect wasn't apparent to others who interacted with the family?
Say that last part again. I'm sorry.
Have you come across cases of abuse and neglect, ongoing abuse and neglect, where that ongoing abuse and neglect wasn't apparent to people that interacted with the family?
Oh, wasn't a parent. Yes.
Sustained.
Your Honor,
You want to approach? You can.
Again, you can fake that you're a perfect. No, no. So the child survived. So blue-haired lady, a 5-minute elevator pitch of this story. This couple adopted a little girl from China about 2 years later, and that went swimmingly. And 2 years later, they decided to adopt another child. They wanted him to be culturally similar to their daughter, so they adopted another child from Vietnam. They went on to have, I think, 3 of their own biological children. Oh, no, you're fine. Their son from Vietnam, who was named Ronan, started exhibiting, defiant behaviors that escalated. Again, cursing, stealing, looking up things that were inappropriate on school computers, jailbreaking those computers so he could look up inappropriate stuff, going into his sister's classroom, having her stand up, accusing her of stealing, going into a classroom, pretending to be part of the school board and saying he was going to audit that class for the teacher, running away. He's very, very bright, memorizing credit card numbers of a friend and then using those credit card numbers to steal money, steal things around the house, stealing knives from a vacation home only to have them have his parents pull them out of a bag. I mean, he didn't stab anyone with them, but he was stealing them. Being unnecessarily rough with the younger children, giving his 4-year-old brother a beer just to see what would happen. So it doesn't sound like the parents were proactive in getting him to therapy as such from the records and what we are hearing now, but they must have come from old school that they kept taking things away. They were recommended by the pediatrician to put him on a low sugar diet. They did start to become worried about him when he was rough with his younger brother. Now, I will say that it appears, or from what I gathered from testimony, as each successive biological child was born, Ronan was constantly moved from his room to make room for the babies. Now, I don't know if that's just how I've interpreted this or if this was just for the last baby. But Ronan had his own room in the house until the last baby was born, and then in Arizona, they made a makeshift, sort of room with a lock that was only, manipulatable on the outside of that room with no bathroom out there, so he would have to use a bucket, uh, out there. He couldn't turn on the lights on and off because he was staying on all night or staying up all night, so they would turn the lights off for him. He was running away, he was stealing things, he was doing bad things, and they were they claimed that they were worried for their family's safety and for the safeties of others, and when they moved to Jupiter, Florida, they bought a $700,000 house that did not have room for everyone in their family, so they had a contractor build an 8 by 8 room, with I guess, a standalone air conditioner, attachment, but again, a door with a lock that was only accessible from the outside, a light switch only operable from the outside, and then, again, no bathroom. So, what I don't understand is if you are able to afford a $700,000 house, why not buy a house with a mother-in-law suite or something like that? It None of this makes any doggone sense, to be very honest with you. But that's kind of the defense is saying that these parents were at the end of their rope. They were worried for the safety of themselves and others. They had tried everything their pediatrician and therapist had told them. The son ran away in early December, and then when they called the police, that's when all of this, how Ronan had been living came out. And they became, uh, charged with, abuse, and he got charged guilty. Now, Timothy Ferreter was given a plea deal for 2 years in prison and 5 years on probation, to plead guilty to, I believe, child abuse. Now I believe that was contingent on him, uh, working against his wife. The cases were joined together, husband and wife were going to be tried as a couple, but then they were severed because Tracy, he was, when the structure was found and Ronan had run away, Timothy was actually out of the country. Tracy tried to claim that the room in the garage was an office and moved all of Ronan's stuff into, the baby room and claimed that he was living in there and tried to, hide stuff and lie to the police. So I think he was supposed to testify against his wife, but according to, kind of exit interviews from the defense attorney after he was convicted, the plea deal was not as maybe hammered down as we were led to believe. So now he is facing up to 40 years in prison. And then after we finish up with this witness, we will go to closing statements, and then we will go to the hearing where his defense is trying to get him released on bond until sentencing. But he's already been convicted, and I don't think it's fair that he should get out, um, and free since he rolled the dice and, picked a terrible defense. You know, he made his choice. It's a weird case because you can kind of had his defense gone with and had these parents, gone to every therapist they could have, had they, had a laundry list of different therapists, different medicines they tried, you know, different outward bound programs. I mean, had they gone to, Dr. Phil's camp, think it over, whatever it is, and this child was, stabbing
Now,
people or
in
something.
cases involving abuse and neglect, can the child who is exposed to ongoing abuse grow a tolerance for the environment that they're in?
Overruled.
Yes.
And so even in cases where that environment that they're subjected to is abusive or neglectful.
Sure.
So there can be a normalization of that type of treatment for the child.
Yes.
Now,
Hey, Sal.
I want to talk for a second. I'm sure I didn't miss anything. About the interventions that occurred. You talked a little bit about that. Defendant provided you with an attempt or a list of their attempted interventions, correct?
They did.
Based on the information available to you, the last time that the victim in this case was seen by a psychiatrist or a mental health professional to address any behavioral issues was mid-2019, correct?
That is true. Although I did, after that, after our deposition, I did receive information that they had reached out to I believe, a medical doctor, a primary care physician, and were asking for referrals for a psychiatrist, but they were in the process of getting the referral from their doctor before he could go to see one. And that was more recent.
So the last time, though, that he was ever seen, as far as you're aware, by a psychiatrist or psychologist was in mid-2019.
Yes.
And recently there might have been maybe we should talk to someone again, correct?
Yes, that's when they moved here.
Right, after they'd already been confining their child for approximately 3 years, correct?
Yes.
They also provided you that they sent one email in December of 2022, or December of 2021, excuse me, that they reached out about a meeting with a transcendental meditation person.
Correct. They were trying to get into transcendental meditation to help calm his behaviors.
They sent one email in December of 2021, correct?
What the actual transcendental meditation? Are you kidding me? Y'all are Shiite Catholic. You're going to send your son to transcendental meditation, not to a therapist. I can't with y'all.
Based on the information that you had.
Correct.
Transcendental meditation is not a medical doctor, a psychiatrist,
No,
a psychologist, a licensed clinical social worker.
I'm not sure who can do it, but I don't believe it is in the mental health field.
And based on the information provided to you, there were no counselors after that date either. He wasn't continuing to
This
see
expert's
a
like,
therapist or a
I
mental
have
health
no
counselor or
idea
a
what
licensed
that
clinical social
is.
worker after mid-2019, correct?
Correct.
And based on the information provided to you, that he started being held in the structure in early 2019, correct?
Yes.
And there also was no indication that an individualized education plan was ever sought at his school.
Right. I believe it was in private schools, no? But
So-
no, they did not.
Yeah, so there was no individual education plan. And then when he came to
yeah, private schools do have IEPs, so individualized education plans. They're what you would have if, say, your child has ADHD or maybe a learning delay, like a speech delay, or maybe they need extra time on a test. They have test anxiety, things like that. But private schools do have those. They're just they're called something different, and I cannot remember the name of them. But they do have a functional equivalent.
Independence Middle in Jupiter, when they moved in December of 2021, January of 2022, there was no IEP sought, correct?
Right. I don't think that, they had just gotten there and I believe it was over Christmas time. So I don't know that they would have been getting it that quickly, but no, I didn't see evidence of it being sought.
Did you see that they reported no behavioral problems when they enrolled him into Independence Middle School in Jupiter?
I don't recall that, but I'll take your word for it.
Now, I want to talk about the impacts this type of treatment would have on a child. I think you've already said that it would exacerbate any pre-existing problems that the child may have, correct?
What would,
The type of treatment, the way that he was kept and confined, correct?
oh, yes.
Would it also, and isn't it true that it's your opinion that it would also make the child feel rejected, correct?
Yes, it could.
It make the child feel like they're not good enough, correct?
Yes, it could.
It make the child feel like they are inherently bad, correct?
Yes, it could.
It can lead the child to maneuver or manipulate through a situation to avoid that isolation.
Yes, it could.
It can lead to depression, correct?
Yes,
It can lead to suicidal ideation, correct?
it could.
When a punishment is chronic, meaning that it happens on an ongoing basis, you will see a bigger impact too, correct?
For sure.
And as to the victim in this case specifically, you think that what was going on with him, the issues that he was having prior, was really exacerbated by how his parents acted towards him, correct?
Yes, that's my belief.
There is a psychological impact, a negative one, when punishment is humiliating and isolating, correct?
Yes.
Now, as to the appropriateness of the punishment, it's your opinion that you don't think anything that they did or attempted to do that they did would help him be better, correct?
Sustained.
Isn't it true that it is not appropriate to punish bad behavior by placing a child in a situation where they don't have access to an ordinary bathroom?
Yes.
It's your opinion that should never have been done in this case, correct?
Yes.
That type of treatment is also humiliating, correct?
Yes.
The same is true for locking him from the outside. That is something that should never have been done, correct?
I agree.
That's also true for the inability to control the lights. That is inappropriate, correct?
Correct.
Inappropriate. That is going to have a negative impact on a child if it happens over a longer period of time, correct?
Yes.
Having a child sit in the dark in a locked room for long periods of time is not an acceptable form of punishment.
Sustained.
It is the type of thing that would cause harm, correct?
Hello,
Sustained.
everyone. Hello,
At
Veilhammer
no
Media.
point is there any indication that
Yes,
these
please, dear
parents were
God.
advised to engage in this type of behavior, correct?
I didn't see any professional telling them to do that.
And that's because it would be something that would not be
Yay.
recommended
Hey,
by
Farrell.
someone within the mainstream psychological and psychiatric community.
Yes, I'm glad you said mainstream, because absolutely there are many professionals that believe in a very militaristic type of parenting, authoritative type of parenting, strip everything out but their
Hello,
mattress,
White
take their
Rabbit
door off the
and
hinges.
Miami
There are
Spice and
professionals and
Indigo
paraprofessionals that do
Luna
believe
and
this
Lil
is a way to
Peanut.
parent, but people that are
Welcome all
mainstream and that
Baker
really know the research
Raiders.
would never have suggested that.
Right. And there's no indication that even these non-mainstream people are involved here and said that you should do this, correct?
Right. I would not know that. Right.
The only advice that we know about is medication and therapy, correct?
That's correct.
That's all the questions I have.
And
Right, would you like
Roseman
Ms. Morrow?
Ranch and Stray and Baker himself.
Dr. Rappa, the state spent some time in their cross-examination sort of challenging the diagnosis of attachment disorder. So I want to talk about that, okay?
Okay.
Is your opinion solely based on the diagnoses that previous providers have made?
No.
What else is it based on?
I mean, that does help to know that previous providers had seen the same thing. But it has to be on behaviors and it has to be on early childhood experiences.
Hello,
Especially
Flux
as it pertains to
and
children, from
Fedorowski
birth to age
and
3.
Jackpot
And
Springs.
in the record, did you see those patterns of behavior that led you to come to your opinion about the attachment disorder?
I did. I saw the severe neglect. I saw the scabies. I saw the malnourishment. And then I saw the behaviors. Or not saw, I saw in the records the behaviors.
And you reviewed Wade Myers' trial testimony. Did the state's own expert, in fact, testify
And
that likely has
Jamie.
reactive attachment disorder from early childhood
And
neglect in his own
Valhalla.
testimony to this jury?
Sustained.
In reviewing Wade Myers' testimony, is it consistent with your opinion on attachment disorder?
Yes.
The state asked you about the deposition that you saw and his sort of affect and behaviors. And the state mentioned that, you know, it's long, he's a kid. Is that what you made of it, or his affect, that it was just because he was a kid and it was a long deposition? Or were there actual things about his affect that were concerning to you? In coming
Hello,
to your
Sea
opinion?
Swept. I can
There were
see
things in
you.
his affect that were concerning to me that went on my radar as I was watching.
Could you take us through those?
Sustained. You want to approach on that, Ms. Mark? Because I think she testified to that in her direct.
I think she did as well, Judge. That's fine.
I sustained.
Thank you
And
guys
so
so
you
much.
maintain the same, sorry, you maintain the same opinion you had in direct examination, correct?
Yes.
The state mentioned, it sounds a little silly in retrospect, but something like transcendental meditation. Did the Ferreters sort of try both medical and non-medical options over time?
Overruled. You can answer.
Yes, they did. They tried many different things. They tried putting him into like karate, and they tried chess club, and then they tried to burn his energy off with track. They did
Let me
try.
Stop you. Are you testifying from your review of the documents that you reviewed as part of your opinion? Or are you testifying from conversations with somebody?
No, sir, I didn't have conversations.
So,
with
all
either
right, so I'm going to allow the answer. You can continue.
Thank you. Go ahead.
Um, They also tried putting him into a meditation class so that he could learn to control his behavior. So I think they tried, and they tried nutrition. They tried taking away gluten. They tried taking away sugar. I mean, there was a bunch of different things that they did try that were outside of the mental health world.
Based on your experience sort of working with families and particularly children with a history of trauma and their parents, I mean, is that, I guess, what do you make of that? Was that neglectful of them and not pursuing every medical option? Or is it something that parents do in trying to?
Sustained.
The state mentioned the transcendental meditation, and you mentioned several other efforts that the Ferreters made. Those are obviously not medical efforts, correct?
Correct.
Does that change your opinion as to whether or not they engaged in malicious punishment?
No, does not change my opinion.
Why not?
I think that they were trying the best that they knew and what they.
Sustained.
Without what you
I'm
think,
sorry. I hope they figured it out.
the state's expert testified that based on the Ferreters' conduct, he believed that there was malicious punishment, correct?
Finish the question. You hadn't finished. I hadn't gotten to the. You hadn't gotten to the question. So finish your question.
Is there conduct that you have reviewed that shows to the contrary?
Yes.
Okay. And can you take us through how you've come to that opinion?
Yes. There's conduct. The tone is terrible. The tone is awful. And how he's talking to the child with that tone is bad. But what he is saying to the child isn't horrible. He's saying, I want you to get better. I want you to make right choices.
Sustained.
Your Honor, there's already in evidence the jury watched the Ring videos.
Response. I remember one of the videos where that was said. So as to that particular comment, I'm going to allow it. You can continue answering it. Objection overruled.
Thank you. Go ahead, Dr. Rappa.
He was saying, I want better for you. People are going to not want to be your friend or be close to you if you continue to act this way. I want things different for you. And while his tone was bad, what was coming out of his mouth was not bad if he had been using a different tone.
Thank you guys so
The state
much.
talked about let me start with this. The state talked about the effect that the Ferreters' actions had. You're not disputing that what they did was wrong, right?
No.
So let's sort of take it back to that 2018 period. The state mentioned a number of different school emails or referrals that had sort of acts that had between 2018 and 2019. Is that fair to say?
Yes.
In cross-examination, they talked about stealing sprinkles, some fights that happened. Is that correct?
Yes.
First off, I mean, how does a psychologist separate what is regular childhood behavior from what is so concerning that it amounts to a disorder?
I think that what we look at is persistence. Is this happening over and over and over? Is it a pattern of behavior? And is this behavior not going away, even though school might be punishing or the parents might be punishing or giving consequences? The behavior continues to persist.
Do you see that as it relates to in the records in this case?
Yes.
Do you see that in this case, in the records as it relates to even prior to May of 2018 when Tracy got pregnant?
I'm going to overrule it because the answer's already been made of record. So it's really cumulative at this point.
You can answer this question and then I'll move on, Judge.
So yes.
The state mentioned that in your work, this is the first case that you testified regarding malicious or allegations of bizarre punishment. Is that correct?
Yes.
Have you testified about early childhood trauma?
Yes.
How often?
Oh my word.
Hundreds of thousands.
A high number. I mean, I've been doing this for 20 something years and, I do trauma work. So a high number.
And when you are sort of hired, do you work for both the defense and the state?
I do.
If you had to put a percentage on it, how often are you working for the defense versus the state?
Right now, probably about 50-50.
And is that locally in South Florida and nationally?
It's throughout Florida.
And have you in fact been hired by this state attorney's office on a number of cases as it relates to childhood trauma?
Childhood trauma. I don't remember in specific childhood trauma, but I have been hired and enjoy working with them.
One moment, Your Honor.
Okay, thank you, Ms. Moran. All right, ma'am, you just remain where you are. Ladies and gentlemen, it's about 12:20. We're going to go ahead and break for lunch for you folks. We'll start back at 1:30, so be outside at the elevators at 1:25 to meet with Mark, and he'll bring you to the jury room. Remember, you haven't heard it for 3 days, but I'll remind you, don't discuss the case with each other or with anyone else doing any kind of research at this point. Other than that, enjoy your lunch. All right, everyone may be seated. Let me have counsel approach you. Ma'am, can you come down here in front of the bench, please?
Okay, you guys, we are going to head on over to closing statements because we are getting done with this trial. I swear to goodness, this trial is like an albatross. So we will stop this screen, present with, oh Lord, and we have to start with the state. I will go ahead and warn you all that the state prosecutor, while she does a good job as an attorney, she has tonally the world's most grating voice ever. So after the closing statements, we will then go to the hearing that was just held to see if good old Tim could be I guess given freedom between sentencing or between now and sentencing, which I think is a little rich to ask for. Considering he did kind of get, you know, it just doesn't seem fair considering the jury has spoken, but we'll see. I don't know that the judge ruled on that at all, but he did look a little disheveled. I know, but we have to in terms of completeness, we have to finish it, but I will do 1.25 speed and we will try to Godspeed through this. It's 19 minutes. We will try. Look, my ADHD wants to not do this and go play with Legos, so I'm trying to be the better person and finish this trial forthwith.
Been medically vulnerable because of past trauma. And instead of doing anything productive to assist that child, they did the worst possible thing you could do. Now, beyond the direct testimony, the photographs in this case, we have hours of Ring camera because the defendant recorded every single moment in that room. And like we said, it's not a continuous stream. It's 1-minute videos related to action.
Yes,
but we have hours
you're right.
of the treatment, of the confinement to prove, to corroborate alone.
Okay, I didn't. Oh, okay. I was about to say I didn't pause her. I promise.
You want to take this thing to the next level? Let's do it. Let's do it in 4-2. Let's do it in 4-2. Let's go.
Okay, so I do feel like it was a, and let me take that banner off. I do feel like it was a mistake to not have the father testify. I feel like all you got of the father were these admitted excerpts where he was being a giant jerk face. So, I mean, that's really all they had of the father. You don't really get, because of, obvious, you're not, the child's not on trial. So you don't get the antecedent behavior. You don't get the initiant behavior very much of what the child was doing. But, so that's, again, they went for the wrong tactic here, in my humble opinion, as a non-legal lawyer of the YouTubes. They attacked the child. They should have sought more help than transcendental meditation, for F's sake. So, but that's just me. Same. Well, not Nikki the name, but I understand.
And so you don't have to take it's extreme that it was dehumanizing.
No, neither is
We have the
First
direct
Lady.
evidence of his actions. This is not a concerned father trying to make a reasonable correction to a behavioral issue. This is a man that is angry. This is a man that has actual malice, that has physical aggression and anger, because we see him put his hands on him, throw him on the bed, put his hands on his neck, scream on him, and then turn out the lights. And so his son is in an 8x8 box. The area that you're sitting in is bigger than that. Oh,
Sustain.
you can use your common sense for how big AP is. Alone. And remember, we're looking through a camera that
I can't with her
has some
showing her
night vision
knees all in
capabilities.
public like some hussy.
Ronan told us what it's like to be in there, that when the lights are off, there is no ambient light. There is no window that he's sitting in the pitch dark. So let's talk about the application of the evidence to the law. Aggravated child abuse. Malicious means wrongfully, intentionally, and without legal justification. What's in establishing or evaluating what is reasonable punishment? Is it corporal punishment? Things that are generally accepted as being a corporal punishment. A strike on the hand, hitting a child on the back of their behind in a direct response as a punishment. Reasonable corporal punishment. Reasonable punishment does not subject a child to a risk of harm. And it does not cause actual harm, like the case here. It is not humiliating, dehumanizing, and cruel. It is proportional, and it is limited in duration. So let's talk about the duration here. Continuous, this is ongoing. And I think that's an important delineation here, right? This is not a proportional reaction to a behavior, like a discipline or a punishment. He has no other room in the house. There is no other place for him. Every other space is taken up. The parents have a room, each of his daughters have this. So there is no situation where he conforms his behavior.
What the state doesn't state, or what is that the child did have a room. Again, his behaviors, every time he did something, he lost privileges. Now, again, this family, I don't know. Let's just finish this.
To whatever standards the defendant wants, and then he is out of the structure in the garage. This is his life, continuous, even in the best case scenario. But we know that it was more insidious than that, because we look at the duration. January 6th, he goes in at 8:10 p.m. That's when they lock up the door for the final time. No more bathroom, no more glasses of water, certainly no snacks. The door's not open until 7:10 in the morning. He's in there for 11 hours overnight. January 8th, he goes in at 9:39 p.m. January 9th, the door is not open again until 8:35 in the morning, 11 hours. January 9th, 8:36 to 7:39. January 10th, 8:36 p.m. until 8:25 a.m., 12 hours. No bathroom, not a drink, not a chance of getting a snack. No way to escape if there is an emergency or a fire. Locked,
and that's a big issue
when we
for
look
me.
at January 13th, 4:49 p.m. to 6:18 in the morning, 13 hours on a regular basis. And the exhibit that the state showed you, all of the ring videos are in from that entire time period. But then we showed you hours of videos that showed every event. So him going in, and then when they come in again, he gets out. So those are the major blocks, the major events. When they come in, they go in, they out. And those are the numbers that we're talking about. When we look at the total in the day, okay, fine, not just overnight. How much of a 24-hour day is he in the room? On January 10th, he goes to the bathroom between 7:39 and 7:45 a.m. or 7:43, so that's when he's let out. He leaves the room at 9:05. He told us he got left around 9 to go to school.
And then what I will also say is, so when I went into this case, I mean, I generally do when we go into a case for the first time, I will read like a short little article that kind of gives us maybe a little bit of an idea of what is going in, or we're walking into. But I don't do in-depth research, because I want us to kind of learn as the case goes on what is going on in the trial. I want us to have the same kind of information that the jury has. Now, the problem is that the mainstream media, for everything that was written about this was boy in box. So it gave the impression that he was in this box 24/7. I assumed almost chained up, deprived of. What went on was bad enough, but again, it's an 8x8 structure. Most rooms are 10x10. If this had happened in a trailer park, again, it's the way it was framed and different things. He was going to school. He was being fed. It was portrayed that they were denying him food. He was at the regular BMI. It was claimed that they were denying him food, but he was a pescatarian, so he wasn't eating normal food. By choice, he was a pescatarian. They were denying him sugary snacks as instructed by a doctor to maybe help with some of this hyperactivity. It's just a lot of the mainstream media reporting on this was sensationalized. So when you walked into this trial, you thought you were going to see this abject, monsterism from the parents. And then you see perhaps parents who are misguided, who started on this course and did terribly misguided, poor parenting. But was it malicious? Was it, monstrous in the way that we see parents who, you know, routinely physically abuse their children, but give them given them back their children by the state all the time. I mean, I'm sorry, but this is probably the same daggone prosecutor that fights to get these kids reunified with their, method acting parents because, oh my gosh, they're doing so much better this month. And, the kids, love them now. And or the Gabriel Fernandez kids, I'm sorry, but we have a broken system. So you've got these parents who misguided, doing horrible, but possibly teachable. Okay? Possibly. I don't know. I've never talked to him. His hair's weird. I'm not going to talk to him. And then you've got these other parents who are just daggone ridiculous, horrible. And I get it, atheists. We're all going to have different opinions. I just the amount of children DCFS lets die in a year in every state is unimaginable, and they're supposed to be the good guys. I can't. The Maya case is throwing me over, but let's continue with Shrieky Lady, and we will continue. Everyone is going to have their own opinion. In chat, let's be kind. Let's consider everyone's opinion. They are coming from a good place. It is not, everyone is going to have their own opinion. This is, a really sensitive subject. So let's be kind and respectful and just be a nice place to have different opinions in our chat, because we were able to do this really well with this case. And let's just finish this mother up.
He returns to the room at 4:59, so after school. And then he leaves the room to go to the bathroom at 5:56 to 6:18 p.m., and then he's in for the rest of the night. So the total, if we go 12 a.m. to 12 p.m., is 14 hours and 22 minutes of a 24-hour day, and he went to school. Huge portions of this child's life are alone in this room. On January 13th, same thing. He goes out for 2 minutes to go to the bathroom at 7 o'clock in the morning, almost 8. He leaves the room to go to school at 9 o'clock. Back in the room at 4:49. He gets dinner at 7:02 and lights off at 7:26. He's in there for 16 hours. If we're going from 12 a.m. to 12 p.m. And he went to school. January 20th, same thing. 6:43 to 6:45. Leaves the room at 9. Back in at 4:45. This time without the lights on. Dinner at 7 p.m. Now, was this every single day? No, because as we look at January 23rd, he gets unlocked. He gets released from the cell his father made for him at 9:07 a.m. and he's not back until 7:10 a.m. So yeah, he's out for most of the day this one day. That doesn't change this though, the psychological impact. And when we look at the proportionality, it's important to remember that the time frame that we are talking about is the crimes that occurred in Florida. And so that is from December 2021 until January of 2022. You can see the things that he is getting in trouble for on that video. He's getting in trouble for stealing candy on that very first night. You stole chocolate from us, his mom says. Having an iPod in his room. Having a bad attitude. Lying. He tells a story about having a mock trial, and that wasn't true. Dr. Myers told us that kids subjected to this type of condition can have a fantasy life because they have nothing else going on. And so they have to have like a myth of themselves. Those are the things in Florida that he is being subjected to this type of treatment for. And I want to talk a little bit about intent, because there was a lot of discussion from the defense about intent. How do we determine someone's intent? For aggravated child abuse, it has to be that they maliciously punished, willfully tortured, or willfully caged. Those are intentional actions.
All right, we're going to hit the pause button right there. You're noticing the defendant.
Oh my gosh. Da, 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 da. Da, da. How did I get this? I'm going to see if we can. Well, never mind.
Structure.
Objection, the statement of the law.
That it wasn't an accident. That's the intention. That he willfully tortured. That he maliciously punished. Not every idea that was in his head. So how do we determine as a jury intent? We look to the evidence. You can make reasonable inferences from the evidence, and we look to his actions and then the things that he said in those
Yes.
circumstances.
I'm
So
hoping
let's
to
look
take
at the
him on a
defendant's
walk after
actions.
this.
That he did not give the victim a room in the house. He hired a contractor specifically to build this. He specified no windows, 8 by 8, lights controlled from the outside, lock, and a deadbolt from the outside. No bathroom. And he put that bucket in there. Each one of those steps are intentional, specific, deliberate acts. It's not an accident that this happened like this. We know exactly what he intended to do to his son. He set up the room. He put the camera in there. And then he forced the child to use a bucket. This is a screenshot from January 19th at 6:46 a.m. where he has to use the bucket.
I really wish they
He
had
had been in the
gotten
room
the
since
other lawyer to
9:12
do
p.m. the
this.
night before.
Oh, dear Lord.
And this happened again and again. And in the morning, on one of the videos, you can hear the defendant tell him to take out the bucket and say, your neighbors don't need to see your piss bucket. From the outside, everything looked okay. But what was happening inside that room? It's abuse. We see that the defendant's repeated actions to socially and physically isolate the child over and over and over again, alone in his room eating. And Dr. Myers told you about the impact of that type of social and physical isolation. His actions to take away every little step and bit of autonomy that he had no control over the temperature even in the room.
Okay.
Did you turn the air on in your room?
Yes.
Are you supposed to touch that? Did you hear Baba?
Yes.
Fed, I've heard that before. Dad,
Here's
don't
question.
leave.
No.
Are you supposed to touch air conditioning?
No.
Why did you touch it?
Just
Okay,
kidding.
Fed, I'm holding you to your promise.
You're a tough guy. You don't touch the air conditioning. I'll deal with you tomorrow on that.
You know, in opening statement, defense counsel said that there was just a design flaw in the room. It's not a flaw. These are intentional choices. This is what he wanted to happen. This is what the environment that he intentionally subjected his son to. An environment that no reasonable person would think was appropriate or acceptable. And then after they have that conversation, both parents come in and ransack the room again and leave him with even less stuff sitting in the room. We have the defendant's actions, his choice that not only would he substantially socially and physically isolate his son, but that they had to subject him to hours of sitting in the dark.
So good attitude? Oh, you're so tough. You're gonna say yeah? You're gonna hold it out? Yeah, bad attitude.
Oh, y'all, don't you remember when your mom's like, wait till I get home and we're going to discuss this? If you are a latchkey kid in the 90s and you are like, and mom said, okay, well, you know what? We're going to talk about this when I get home. You were at home scrubbing and cleaning and like, okay, maybe mom's going to forget about all of this said, quote unquote punishment we're going to talk about here later. Look, my mom never forgot. She's like, shouldn't say she's like an elephant. That would be terrible if she ever watched this. My mom never forgot. And my mom had bat ears. So you could not mumble under your breath because she would hear it like from 3 doors down and around the corner. Yeah, no, the dad devolved into a child himself. And that's why the dad should have testified, because all the jury got to hear of the dad was him being an absolute dill hole.
Okay. What's this here?
I mean, to be very honest, that's all the jury got to hear of
What we
the
have
dad
here is
was
anger
an absolute
and
dill hole.
derision. We have spite, and we want to cause him harm. That's why you're not trying to address behavior. What you're trying to do is maliciously punish him and make him sit in a dark cell for hours during the day. When we look at, oops, this one. This is a few minutes later.
Oh, you're so tough. You're gonna say yeah? You're gonna hold it out? Yeah, bad attitude. Okay. Okay. What's this here?
Sisters, sisters, never were there such. I keep telling my girls they should thank their lucky stars because I've never made them don taffeta skirts and sing that song with fans, and I've never made my boys, uh, well, don taffeta skirts and sing that song also. So really, I'm the best mother ever. By virtue of simply not making them do the White Christmas song, though someday they will be made to, probably on my deathbed, because I demand it. Dang it. I birthed you and your giant heads because I have giant-headed children. I demand you do this song from my favorite movie and do this song, please,
Bad attitude? Yeah. All right.
because I have
About like the reasonableness of the punishment. Like, look what he's doing that for there. He has a bad attitude. His 14-year-old son has a bad attitude, and that's why he gets to be locked in a room with no lights, which to talk to, Dr. Myers told us is the same as solitary confinement, something that is universally condemned for most humans, but certainly for children, because of the psychological harm that type of treatment causes. And we can see about how often that type of thing is happening. The camera is installed in the room on January 5th. That's the very first video we watched. And we went through each of these. We see that on January 9th at 8:36 p.m. They're mad at him, he's in the dark. No ambient light, a 4x4 room. On January 10th at 6:18 to 7:06, again, dark. On January 11th, 4:45 to 8 o'clock at night, and he doesn't get dinner that night because they're mad.
Scott, pull the mic up because it's a recording issue for
Because
me.
they're mad. No dinner. On January 13th, again,
Your
4:49
Honor,
to 7:02,
no one is
2.5 hours in
ever
the
going
dark
to
in the middle
not
of the
hear
day.
her voice.
And then they come in, and at 7:55 again for the rest of the night, pitch dark, no ambient light, not a window, 8x8. On January 14th, again, 4:49 to 7:02, he is sitting alone in the dark. Like Dr. Meyer said, systemic, ongoing psychological torture of a child. January 15th, 5:04 to 7:32, 2.5 hours more in the dark. On January 19th, 7:45 p.m., those lights get switched off again. On January 20th, 4:45 to 5:51. January 24th at 7:08 p.m., he's in the dark.
Look, y'all, I know that gentle parenting is a new thing that has been invented after the latchkey kid thing that I grew up in. Because if I was doing half of the things that this kid was doing, Mo would still be in a coma. Okay. And I am in no way endorsing any sort of physical abuse or anything. I am just saying that my mother would not have responded. I let me try to pull that up. But yes, I can probably do a poll. It will definitely distract me from this
And
woman's
then
voice.
January 28th is the last day.
I
It's
just
the day
need to
that he runs
find
away.
find
The defendant made
my
deliberate, intentional actions. He
self
put
in
his
all
child, a child that he knew was
175,000
vulnerable because of his early childhood
tabs I have
experiences,
open.
into this circumstance. Every single night, for periods of time during the day, he locked the door over and over and over again and didn't allow him to even control the temperature. His only option was to use the bathroom in a bucket, and he had no access to water on multiple occasions.
Vinnie Politan, thank you so much for joining us
Oh,
tonight.
hush. Hush yourself. Okay, so that is over. So we will go to I should have pulled up the next one. Oh, for the love of all that is Cheetos. No, I want now the defense.
Most in science.
Okay, now where am I here? Maybe I'm here. Awesome. So stop this screen, present, share screen. At least we have the soothing tones of not Shriekella, because holy crow. Probably. Yeah, they probably couldn't understand taffeta. They're like, think, oh gosh, tulle. Okay, that stuff that they put in tutus. That's what it is.
which is Dr. Rappa talking about a neuropsychological exam. So that neuropsychological exam, as Dr. Rappa testified to, has multiple parts. And this is testing that the psychological and psychiatric community relies on routinely. And it allows us to have data about a person to explain how they are the way they are and why they are the way they are. This neuropsychological testing has multiple parts, and it includes something from Ronan. Dr. Rappa explained that. And in this particular testing, there was no reason to believe that there were any sort of validity issues with the information that she received. She also said that even though the testing was from just a couple months after January 28th, that doesn't matter because it still is a test of executive functioning. What that test has clinically elevated levels as it relates to inhibition and emotional regulation. And what Dr. Rappa told us is that that means it explains this sort of persistent behavior that's not stopping, that becomes or has sort of a strong emotional reaction. He's not able to control that in the way another person might be.
All right,
He also
pull
has
this
a lack
up,
of inhibition.
I believe.
And that's
I
why
might be
when
right.
he has consequences, that's not something that he's entirely understanding.
Look,
She
I
said
love
that
handy
it's
talk.
very hard for
She's
someone
Italian.
who tested like Ronan did to be in control of themselves, and they have a lack of insight into their own behaviors. She also explained that this testing, right, goes back to early childhood, and that's not really in dispute. The state's own expert, Dr. Wade Meyer, probably an attachment type of disorder from the time that he lived in an orphanage. Again, there's no dispute that the ferreter's actions exacerbated that, right? Dr. Rappa told us that. That's something that the defense is completely conceding. But both Wade Myers and Dr. Rappa say that this it is from very early childhood neglect. And what we see and what the key is, and Dr. Rappa talked about this, Wade Myers had to concede to it, their behaviors
Under
before
petticoats, if you want to
2018,
dress
right?
in
That's when we're
vintage
talking about the
style.
timeline.
It's the very fishnetty looking stuff. It is not comfy to wear unless you get very high quality.
Latch was put on his door in Arizona. So that has to be late 2018, early 2019. Prior to that time, Dr. Rappa testified about records that she reviewed from 2015 elementary school emails about ongoing and persistent behavior. And I asked her, because look, I understand, and the state made light of it, but stealing sprinkles or activities that are just considered childhood behaviors. It's very hard to distinguish what constitutes regular childhood behavior and what constitutes a disorder. And I asked Dr. Rappa that during her direct examination. And what she said is that it is the persistence of these behaviors, that despite there being consequences, despite there being boundaries, they continue and continue and continue. In cross-examination, Ronan admitted in great deal to his own behaviors, right? He admitted to harming other people. He admitted to offering his brother beer as an experiment. Sev De Borzati testified that a time that they were visiting with knives in his backpack. And the cross-examination on that was, well, did he threaten you with a knife? Did he use a knife? An 11-year-old shouldn't have knives in their backpack, right? That's everyone's common sense. That as a young child, there are certain things, certain boundaries that you cannot cross because you're a kid. From his own home, stealing from the parents of some of his friends. He admits to running away.
I swear Fry
He
is a
admitted to
cat.
breaking into his tablet
the
at
day.
his last school in Arizona and
And
searching violent terms that concerned his parents. And that was the reason why he
With
had to get his
brief
technology taken away.
Periods of zoomies.
Kellen McCoy about an incident that he had with his sister. And in cross-examination, the state was asking Dr. Rappa about these sort of specific incidents, trying to minimize them or showing that, any one act is.
As we approach the top of the hour, I want to thank Lateef Gray for joining us this hour.
Oh, yeah, he didn't testify. And I think that was a mistake, but I also think that the defense,
Down a plea deal of 2 years. I'm not
About 2 at a time. I'm going to pick it up where we left.
I think the defense Fry is a non-Newtonian fluid. He he is just whatever it is. He does what he does. I can't explain Fry. He has his own thing. He does he lacks the delta brainwave. He is his own grandfather as per lore and canon.
Being a kid or immaturity is never a big deal. But it's when it continues and doesn't stop over and over and over again, and when it escalates and when it becomes persistent, and when in this case you have a neuropsychological exam that supports that it becomes a disorder and something that is problematic to the child, to the parents, and to everybody that he's around. So Kellen McCoy entered his sister's classroom, had her stand up and humiliate.
And what I will say is if they had a better fact pattern, the fact pattern was horrible in this case for the defense. They should have taken the plea deal. I waffled on that a bit. Well, Eris, there you go. You're I'm glad that I have worked on I have helped you this Friday with your healing. There you go. But I the fact pattern was bad in this case for the parents. I waffled on whether he should have taken the plea deal. Um, I very strongly believed he should have in the beginning. I kind of waffled in the middle, and I'm back to believing he really should have just taken the plea deal because the facts in this were very bad. I think that the defense's strategy of attacking the child was bad, but I don't think that they had the fact pattern to go with my strategy, which was showing parents that had tried so many avenues to get help for their child. Because if they had shown parents at the end of their rope that had gone to, X, Y, and Z therapist, had got, gone to transcendental and dental meditation, gone to, Taekwondo, Taibo, P90X, all of the things, then you maybe could have had a different and more palatable defense. But with what they went with, it's not hard to see why he got convicted. And I don't like this that they went after the child. I think that was the wrong way to go about this. As a non-legal layperson, though, that's just my opinion. And I think that again, the jury only had, Tim being a major dill hole as their
her in
only
front of
point
the
of
entire
reference.
class. And during cross-examination, I recall Ms. Coakley saying something to Dr. Rappa, and Dr. Rappa was like, "No, but it seems small, but that's not the case." And Ms. Coakley interrupted her
Welcome,
at that time.
Alexandra
But
Nolan.
you have to think about the steps it takes, right? To decide to go to an entirely different part of the school. Pretend to be another person. Decide to point out your sister.
And I
Go
think,
to that
Eris, I think
classroom.
it
Have the
definitely
courage to come up with this entire.
I think a lot of us bring our own childhood experiences, so it's such a different case in perspective, depending on how your childhood was, what maybe trauma or lack of trauma you have in your childhood. It's a deeply personal case, I think, for everyone. And I do wonder, obviously, I do hope that the child and all the children are getting help and support, especially, Ronan or Ty, to become, oh, well, thank you so very much. Help to deal with the trauma of being locked up. I mean, obviously, this was the very worst parenting thing that they could do. I did state this earlier in the stream, but for those of you that came in, the last expert that the defense used was Dr. Sheila Rappa, and I think she was a very knowledgeable expert in sort of early childhood trauma, dealing with this reactive attachment disorder, a very troubled child, oppositional defiance. It does look like she has a private clinical practice. I am going to see if she has an email of maybe resources that she could. Obviously, I think she's going to be very busy. I don't think she's going to want to be interviewed by a YouTube channel in regards to this case, but possibly she would email me back with some resources that parents can look at if they are sort of struggling, if they are dealing with children that are, you know, maybe not the easiest to parent. What are things that we can look for? Because obviously we've seen, what not to do, but these are really challenging, economic times, international times. People are stressed. So, perhaps she will get back to me if I email her this weekend or next week, and I can share that with you guys because I do think that, there's no guidebook for parenting. And she did seem like she was very personable, very knowledgeable. I think she was just really good at a lot of things. So hopefully, you miss 100% of the shots you don't take. So she may not respond back to me, but if she does, I will pass on that information to you. Right after this, we will go to the hearing that Dad came back from cigarettes. My childhood trauma. Well, there you go. He said, "I kept my word. I'm back. I didn't even smack the clerk when she failed to ask me for ID for cigarettes to placate my aging ego. I think I did well." Yeah, I always ask I'll have to show you my clearance booze haul. My one super talent is I can find clearance booze. And for a person that doesn't drink as much as I wish I could, or I don't drink as much as I buy clearance booze, so I'm stocked up for Armageddon. But I found a bunch of clearance booze today at Kroger. I don't know. I guess they're redoing their stock, and the lady was like, "Oh my gosh, where do you find this, this, and this?" And I was like, "Oh, it's in your secret clearance section." And if you know where those are, you know where those are. And if you have 8 people in your family, you know where those are. But, oh gosh. So we'll go to the hearing where, right after that, where he asked for to be let out on, GPS monitoring between sentencing. I don't think that the judge went for that, but we'll have to hear what he says. But, spoiler alert, he was found guilty.
Entire story. That is something that gets to the level of being manipulative. And those are the concerns
It really
of
was
his life.
Lucy.
And that's corroborated per Dr. Rappa prior to 2018 through records that she reviewed, I think she listed off 25 items or 26 items that she reviewed and coming to her opinion.
Early, I'm like, aren't you going to ask for my ID?
Dr. Rappa also testified how when you have a lack of trust in a parent-child relationship, and I guess you can rely on your common sense for this, but when you have a kid, right, and they're growing up, you rely on trust. But we rely on that in any relationship that we have. That what we see is we get. Right? That what we expect when someone says, I'm going to do this or I'm not going to do this, that they actually follow through with that. And that relationship of trust is really important between a parent and a child. And when it is broken, Dr. Rappa said that the response that a parent has, the natural response, is to control. Right? And we see that in our everyday lives. If you have a kid who's out, joyriding, you don't get the car. Right? If you are someone who is fighting at school, you're going to be in a timeout. You see in this case that it is taken to an extreme, but it is also in response to an extreme because that kid joyriding who doesn't get their car stops, Most people's children stop when they say, you can't do this anymore. I'm going to take away your items. I'm going to put you in a timeout for a reasonable amount of time. I'm going to ask that you stop doing it. I'm going to ask that you not, hurt people at school. I keep getting emails from school about how your violence is becoming a problem. I need you to stop doing that. Eventually, kids
There is no
stop
explanation for Fry.
it. It persisted over and over and over again for years. I want to show you a video of how Tim Ferritter
And you want to run away? See how that takes you. I'm not chasing you this time. See how it goes. If you want, should I put this ankle thing back on you? Because I kind of need to know where you're at, just so you don't get hurt yourself. What's out there? You think you do. All 14-year-olds, 15-year-olds, these kids you're around, you might think you know what's going on in the world, but you don't quite know. Give it a try. Go ahead. But I got to put the ankle bracelet on you. Because I'm responsible.
Oh
And when
my
say, I'm not
gosh. I
giving
remember
up,
Green
I'm not
Day,
quitting.
American
You got me
Idiot.
forever. So deal with that.
I know. Remember when eggs was a
Destroy
sign
this
of
shit.
richness?
I'm not going through this again and again and again. Deal with Nola to the next step.
You can hear Tim Ferritter, and as Rappa said, in the worst tone ever sometimes, attempting to parent, right? And it is not perfect. I don't think any parents, would say that
For
their
the
parenting is
love
perfect
of all
or
that is
even
melting
great in
puppy,
retrospect.
Fry. What
But
is
what
wrong
he's
with
telling
you?
him is, if you keep running away, I'm going to have to put a monitor on you. And of course, that sounds like an extreme thing to do. But what he tells him is, you're 14 years old. You don't know what's out there in the world. I have to keep you safe.
All right. So that's that. And let's go to the hearing. I am like almost semi-professional having this almost sort of set up and ready to go, sort of. I only have 80 bajillion and 12 tabs open. Okay. Okay, I might look into her. Let me write her down. But that is a good place to email too. So thank you very much, Lucy. That is a great. I might, I might need a break from this case, to be honest. This was not an easy one. Kid cases, even when I kind of picked this case thinking that this would be an easier case since the child was still alive. Oh, Vale was salty about what? I don't know. Because the child was alive, but it's a lot of even though this child is still alive, I think it was a little bit difficult just with parenting is hard.
Ms. Ryan, it's your motion.
Holy-
Proceed.
Oh no, they're letting cousin Lemmy talk.
Judge, we're asking
It's a
for
terrible
a
idea.
bond pre-sentence
you,
for
Lucy.
Mr. Ferritter. He
Oh,
was
okay.
charged in this matter by information in March of 22. He was out on bond, on a $50,000 bond is my understanding. From then up until the end of trial, he never missed a court appearance. He appeared as the court required, either live or by Zoom, for every appearance that was required by the court. Currently, the sentencing is set for November 16th. It's less than a month away. It would be of great assistance to the defense for Mr. Ferritter to be out of custody in order to assist in our preparation for the sentencing hearing. He currently is able to put forth a bond package of $100,000 monetary bond, surrender his passport, and provide and is willing to use a GPS monitor, level 1.
Okay. Anything else, Mr. Wayne? You intend to put on any evidence in regard to this motion?
I am not. I'm relying on the fact that the docket reflects the fact that Mr. Fairder has never missed court. The purpose of bond is to continue to make sure that the defendant appears for court. There is no doubt that Mr. Fairder is going to appear for his sentencing hearing. He's appeared all the way through and continues to intend to comply with all of the court orders. I would also point out that he does not have any custody of the children, and therefore there is no issue there. We are, as I said, preparing for testimony for the sentencing, and we may be needing to prepare his statements as well.
And
Right,
that
so,
can't happen in jail
Even though you're
because,
not going to put on any evidence, let me have you at least speak to the issue of flight risk, because that's obviously the central issue to a court anytime you're considering post-conviction release, whether it's pending sentencing or even after or pending appeal. I don't know anything about the defendant's background in the sense of what his financial resources are, what his travel experience is, that guides me and informs me as to whether he could be a flight risk or not. And so are you going to give me any enlightenment as to that, through the evidence? Because the cases that I've read on this tell me that I can't just draw a conclusory determination that a defendant is a flight risk, and I have to base it on specific evidence. But in this type of motion, the motion burden would be
oh,
with the
he had to
defendant,
try
right?
to do his hair with
agree with that?
water.
I do,
That's
which
so
is
sad.
why, in order to deal with that issue, because from our position
I
in
am
terms of the
not
bond
sure.
request, we have to be able to deal with that issue in our bond package, of which that includes surrender of passport.
Yeah, I
which
don't
I'm
know
prepared
why
to
they
do
went
today.
with Cousin
I have it with
Lemmy.
me. I'm also be able to tell the court where he'll be residing. I don't want to do it right now in open court, the address, but it would be in Palm Beach County. So he would be under the jurisdiction of this county. He would also, as I said, have a GPS monitor level 1. And so all of the issues related to flight risk can be managed through what I've been proposing. I do think that, and I'm sure the court is aware that he has lived in another state at some point. So in terms of travel and that sort of thing, there's no intention to leave the state of Florida. In fact, not even leave the county of Palm Beach.
All right, anything else, Mr. Whiting?
No, not at this time, Judge.
All right, Ms. Coakley?
Your Honor, there is one case that I was able to find on it. I'll provide it to the state, which is Kraft v. State. And that case basically stands for the proposition that it's in the discretion of the court. I can provide it to you.
No, I have it. I already have it, and I've read it.
And the thing that Kraft says that we look at is flight risk, as well as they said that was an important consideration was whether or not there was a mandatory prison sentence in this case. There is.
Speak to me on that, because we're obviously not at sentencing yet, but in looking at Kraft, and also I think it was the Cheatham versus Novell decision.
Okay, yeah. Where did Cousin Lemmy go to law school? I mean, state's attorney comes in here with, like actual legal precedents and case citations or whatever you call them in actual legalese. And, Cousin Lemmy comes in here, well, he showed up to all his court dates, and he's a pretty good guy. I mean, why not? I'm confused. I am confused. Where did Cousin Lemmy go to law school? Also, Cousin Lemmy, I love you. Just could you try to maybe have like some Kate's citations when you go up there and ask for things? Because you look a little befuddled.
One of the things that I can consider is whether there is a mandatory sentence involved, because that informs on the issue of potential flight risk. So tell me what, without obviously.
Does look
us
a
going to the
little,
sentencing hearing at this point, tell me what the mandatories are.
not
that we are
so
looking at.
great.
The bottom of the guidelines in this case is 75 months.
75 months. So that's
5.5
a little over
years.
6 years.
Correct, Your Honor. And obviously, Your Honor has discretion all the way up to 40 years.
Ooh, I
in the
almost
Department of
mathed
Corrections,
right.
which is a substantially significant posture than when the defendant was on pre-trial, especially since the state, first of all, he's convicted, and second, there's additional charges here. He was on pre-trial release as to 2 charges. Immediately before trial, the state added a 3rd charge. So that's a fundamental difference in his position, besides the fact that he's been convicted, and now that there's a mandatory prison sentence. That creates a substantial risk of a flight risk, Your Honor, that was not present before, and also leans against that it would be appropriate for pre-sentencing release. I think, Your Honor, as Your Honor knows, it's an incredibly rare thing for there to be a pre-sentence release. There are very specific guidelines that dictate post-sentence release. But this type of posture is incredibly rare, and I cannot think of a case in my career where there was a pre-sentence release.
I tend to agree with you, but in anticipation of this hearing, I did a significant amount of research myself, and I was already familiar with the Kraft decision.
I think they do some cases in months. I am not quite sure though. I do know like they do 84 months or sometimes 20. I know they do financing in months, but look, that's only because I use quad pay most of the time. And then I try to convince Mr. Mo that it's only $24, 4 times and not $100. Now, that has never worked out in my favor in convincing him that we did not spend $100. We spent $24 4 times. It rarely ever works out for me that we actually get that sold as a concept. But that's how I know
Your
those
discretion. That
things.
is the accurate statement of the law. And you could do it.
It is, and let me tell you, I don't know if you reviewed the Batiste versus State decision. That's at 134 Southern 3rd, 1025. And this is a decision that, because my general feeling of
We
the
do
law is what you
sometimes.
just stated. It's exceptionally rare to grant bond pre-sentencing. But in the Batiste case, the court made a couple statements, and one of those statements that gives me some concern in terms of what I have to decide here is the exercise of that discretion. And basically, the Batiste decision said that a trial court judge does not satisfy the requirement to make written findings in support of denial of post-trial release, because if I deny this, I have to do a written order by merely making conclusory findings unsupported by the record. Rather, the rule governing such motion in the Youngins decision, which is where the post-conviction guidance comes from in terms of bail or bond pending appeal, on which the rule is based, embody the Supreme Court's determination that decisions regarding post-trial release must be reasoned, and therefore a mere verbatim recital of the considerations in Youngin will not suffice to fulfill the requirements. And so what I think that tells me is I can't just draw the conclusory or make a conclusory allegation that he's a flight risk. I have to be able to point to evidence in the record that would substantiate the conclusion that he's a flight risk. And so with that in mind, telling from the state standpoint, and I think you've already pointed to one, the minimum that sentence that he's facing, the guidelines, and then the maximum up to 40 years. Are there other factors that would weigh in support of the state's position that there's additional evidence like not sufficient ties to the community, world traveler, those kinds of things that would affect my decision?
There are, Your Honor. And I think that part of this is it's the defense's motion, and so they should bear the evidentiary burden of establishing that he's not a flight risk. He came to trial and came to prior court dates. Is not, I think, a sufficient legal basis for Your Honor to conclude
Thank
that
you,
he's not a flight
blue-haired
risk. Right? They have the
Bible lady.
evidentiary burden.
Bye.
And that the state has to
Have a
reflect that.
good
But I would say
day and a
based on the
safe day.
information that we have in this case, the defendant has huge international contacts. His very close friend flew from Australia for the purpose of testifying on his behalf. And so he has contacts throughout the world who have made extraordinary efforts to be in support of him. In addition, the defendant has resided internationally. He resided in Spain for a period of time during the time when with the children at a certain point. And so, and I also think as to say that he's a flight risk, there is no local residence. The defendant, the home that was at issue in this case was sold. Based on the information the state has, we have no indication that he owns any local property in Palm Beach County. The defense has not provided the address of where he will be living so that there can be any checks as to the ties there. He also is not the one that posted the monetary bond in this case. The bondsman was supplanted in this case by a friend who posted the entirety of the bond. And so the financial risk here is not the defendant, it's one of his supporters. And so that is a consideration as to whether or not a bond would be an appropriate check here, because he doesn't have a local residence. He doesn't have any financial involvement in the bond if it's being posted by a friend. All of those are considerations. In addition, the defense has articulated that he doesn't have any continuing contact with the children. That is just not true. The youngest child in this case was adopted by his co-defendant's parents, and he's had continuing contact with that child even since he's been in custody. And so there is a substantial risk. And I think it's important to note that that child was removed from his custody by the Department of Children and Families. That dependency case closed when the adoption took place. And so there's a risk even that he'll have continuing contact with a minor child or even be living in a home with a minor child. We don't know that because the defense hasn't provided any evidentiary
I've
support
gotten better
for
at
where he'll be
reading
living,
them
who
before
will
I
be
put
willing
them
to,
up.
whether or not only we can prevent him from fleeing,
Sometimes.
but we can protect the community from someone who has now been convicted of multiple crimes against a child. And so based on all of that, I don't think that they've reached their evidentiary
For the
burden, but there's
Halloween
substantial
spirit.
support for the idea that he has a risk, especially in consideration in light of the bottom of the guidelines in this case in a mandatory prison sentence.
Okay, all right, thank you. Ms. Coakley, rebuttal, Mr. White?
Yes, cousin Lemmy, did you have any of this thought out?
I'm familiar with Kraft. The issue in terms of burden to start with is it's our burden to deal with the securing of his return to court, which is the entire purpose of bond. And we're dealing with that through the issues that we brought up as to surrendering his passport and a GPS monitor, and that he will be residing in Palm Beach County. In terms of the address, I'm happy to provide the address to the state. I'm happy to have them go and do whatever they need to do to make sure that there's no child at the house or anything of that nature. In terms of the bond amount, there's nothing in the case law that says who puts up the money. That was irrelevant. And in terms of
Why is it irrelevant? Because bond is typically, it creates financial exposure for the defendant putting up the bond or for his family that's putting up the bond. If he's not the one that put up the bond, why isn't that a factor
I
can
endeavor
consider,
to be funny
in the sense
sometimes,
that,
Paris, but I don't
the
want to
normal,
be.
scenario where the defendant would feel the financial pressure of the bond doesn't exist here if someone else has put it up.
Well, because first of all, even if as to the
I'm sorry, Fed,
previous
that's
bond,
not
this
nice
is
of
what we're
your
talking about,
wife.
right? The $50,000 bond, sure. So clearly, he did continue to come to
And
court on
I'm
that.
terrible
So
at
the evidence
grammar,
in the
so you
record
didn't
is
even need
that
to
it did
correct
work. He
that.
did continue to come to court all the way through trial. So there's no issue that I don't think the state's even saying that he missed a court date. So there's no issue that
I
didn't
have
work.
no
Of
idea.
course it worked. We know.
This
We
family,
went all through the
entire family
process.
makes no sense.
Except the scenario is radically different now, post-conviction. Do you agree with the representations by Ms. Coakley that the defendant has sold his home in Jupiter that was his residence at the start of this trial, and he no longer owns a residence here in Palm Beach County?
One moment, Judge.
And while you're asking, meeting with your client, I'd like to also know, do you agree with Ms. Coakley's representations that the defendant has lived in Spain for a period of time with his children?
Shouldn't you know this if this is your client, you giant dingle hopper? Is that a tat I see, or has that dyed his hand? Or no, that's a tat, maybe. I don't know. I shouldn't be looking so deeply at his bicep, but I am because I'm a weirdo.
It did come out even in the trial, and so the state knows that Mr. Ferrer did live in Spain, but that was in 2009. And that issue of international travel is remedied by both the surrender of passport and a GPS level 1 monitor. In terms of does he own a home, he does not at this point own a home. It is not the first time somebody who doesn't own a home, though, can still, live somewhere and not be in custody during the pendency of the case. We're looking at a relatively short span of time that we're asking for. We're asking for from now to November 16th. So I think that steps can be made to deal with any additional concerns the court may have, but flight risk should not be one. Because with no passport and a GPS monitor, the court would be
I do like
informed
this
of
judge
any
very
violation
much.
of that situation. And if he's in Palm Beach County, he's under the jurisdiction of the court the entire time. So I do think that is remedied. In terms of the issue of is the mandatory sentencing, my understanding of the years I've been doing the mandatory sentencing, what we're talking about is if there's a minimum mandatory statutory minimum. There really isn't here. There's a guidelines range, and the bottom of that guidelines range is as the state just put out. But
Do you agree that it's 75 months as represented by Ms. Coakley?
I have no idea what it is.
No reason to.
I have no reason to doubt
Cousin
it.
Lemmy, did you read the statutes in this case? Again, y'all, I want you to remember that Cousin Lemmy is representing someone in a death penalty case. That man better be right with the Lord our Savior, okay? Or his Savior, or whomever he prays to, because Cousin Lemmy is representing him in a death penalty case. And he's going to be like, look, I haven't really read the statutes in the death penalty case, but like I said, my client said he didn't do it.
I just don't know what it is. I let the
Oh,
state
for
score.
flip's
I don't really
sake.
bother. But I will say this, that the court can downward depart, the court can upward depart. The court has full discretion at sentencing. The court knows that. So there's
Y'all,
no minimum mandatory in that sense. So we've dealt with both the issue of flight risk. We've dealt with the state's issue as to that.
that isn't really his name. Oh, for goodness sake. His real name is Mr. Wadi, I think. but I've named him Cousin Lemmy because he's like my cousin Vinny, only terrible and horrible and very bad. And I have in my mental headcanon, I have decided that the good attorney, the good female attorney, was forced by her family to hire Cousin Lemmy as a family favor. Uh, that's how I figured he got the job. And, sir, I'm making fun of you because you are ill prepared at every turn and you're just terrible, but I'm sure you could do better. So try to do better. I don't want to make fun of you, but you are driving me insane.
Dramatically changed. The only additional charge, which was put on, I think, a week before the trial, was the neglect charge, which is an F3. It doesn't substantially change the score, quite frankly. And I do think that it's important to note that we're looking at a very relatively short time frame that we're talking about before we get to sentencing.
But it's a relatively short time frame that follows the conviction and adjudication by the court on the charges. So I know I'm telling you what you already know, that radically changes the calculus between pre-conviction, pre-trial, and the considerations that I look at post-conviction. I mean, the risk of flight is
That
always an
might
issue even in
be.
pre-trial, but once
Yeah,
the
it might
adjudication
be a
occurs,
bruise, but
it's something that we really
it
have to look
also
at that
looked
point, because
very
now we've
similar to
passed
the
the precipice
dye of the
of an
scrubs.
adverse
So
jury verdict at this point.
the
So,
scrubs could not be very dye
any
resistant.
additional argument you wish to make on any of the points that we've raised? Any other factors in
have-
Youngins that you would ask that I consider? And I get that Youngins is the standard for bond pending appeal, but some of the cases I've read said the same considerations are appropriate for bond pending sentencing as well.
Well, I think Youngins and his progeny really also talked about the fact that what is the purpose of the bond? The purpose is to ensure the defendant comes to court when the court requests it. And I think you can look at, in terms of evidentiary value, the record in this case, going back to March of 22, where, as I've said a few times now, he's never missed a court appearance. I think that the hypothesizing of what might happen should be better predicated upon what's already happened. And so we know he's come to court. We know that whether he
I'm not
was in
touching
state
a
or out of
Ouija
state, he
board.
made
Oh,
those,
no,
he made
we are
those
not
appearances.
doing that. We
In
are
terms
not
of the
saying Bloody
bond,
Mary
whomever
in
put up a bond in the past doesn't
mirror.
have to be who puts it up in the future. If
Look,
the
this
court
house
wants
was
some
is
assurance
state of
that
the art.
Mr. Ferrier is
1974. We are not inviting any evil into this house already. We already have, you know, wood paneling, or as I like to call it, vertical shiplap, which the realtor said I can't do that. Apparently that will not sell. So when Cousin Lemmy went to discuss with his client, which he should have already known that his client had sold his house, there is a dark blue or purple kind of thing, and it could be a shadow from his, prison garb or something, but I was trying to figure out if it was a tattoo. I don't know.
participating and putting up money of his own in this bond, we
Fed.
can put that as a condition. But I do
I
think
have a
that it would be
wild,
a
feral,
assistance to the defense to prepare in a short
semi-Viking.
span of time
You know
for the
he would.
sentencing to have
He would conjure all the minions he would have. He would become a Sith Lord, and he would use all his powers wrong. I cannot unleash that upon the world.
better access to Mr. Ferrier between now and November 16th.
All right, thank you. Court is going to take this under advisement. My review of the case law and of the rule tells me that I need to make specific findings in regard to my ruling on this motion. So that's going to require that I put together a written order, and I will move promptly to get an order out as quickly as possible. But it's not something that I can rule from the bench without doing what the cases tell me. And the rule tells me draft an order with findings to support whatever my ruling is. So anything else I need to address before we recess on this hearing?
No, Your Honor, but if you're at all inclined, the state would absolutely recommend that he can have no contact with children and no contact with the co-defendant should he be released. So I just think that would be very important to the state.
Okay. All right, good enough then. Court is in recess. Thank you.
All right. So that is all. That is what we have done with that case. And as promised, I went to Kroger and let's see, we got Cosmo pre-mixed stuff, so awesomeness, for $7, which is awesome. I don't drink. This is hilarious. Mr. Mo is going to laugh because I have boxes. Loyal mixed berry 9% alcohol lemonade, which I will probably cut with Diet Sprite. So this will probably last me for years. And then I don't know. I am not a big fan of these seltzer drinks, but they were also on clearance. And if there is one way to trap a Mo, it is with clearance. And these were on clearance. They're tea spritzers. And I'll also probably cut those with Diet Sprite because I'm classy. Look, I've stopped the box wine. Yes. So, but one can always cut with Diet Sprite to make things less boozaholic. Because that is how we roll. And that is all for today. I think we have, if you guys know of any trials that are starting next week that you would like to, yes, they do. Yeah. So there were some things that they have done. I think that they realized that they did not have a good fact pattern. So I don't think that he should get out. Like I said, I think that they are trying to play the system for some reason. And I feel like, he rolled the dice. He didn't take the plea deal, and this is what he got. But that's my opinion. Everyone is allowed to have their own opinion. We all have noses and behind holes and opinions, and everyone's allowed to have one. That being said, we are done with this case. It is in a box with a bow, and we will find out about sentencing. I will write that down. Jury selection. Charlie. Okay, I will do that one. And then if anyone else has any suggestions, I am on Twitter. If any of the mods could put that link up there. I am also on the MLS Discord. I haven't started my own Discord, honestly. I'm a little okay. That's a oh crud. Okay. I'm not sure if I would be able to handle my own Discord. That's something I am thinking about. But right now I'm on MLS's Discord. So if you have a membership to Making Law Simple, then I am on there. And if you have any cases that you'd like me to cover up in the future, I will still be looking at the Delphi case. I am going to start making single stream episodes, videos or streams, I'm not quite sure, of suspects that have been from the start of the case. So starting with Ronald Logan, the property owner that was was adjacent to the crime scene, will be my first episode or video. And then we will move on to other chronological suspects in the case so that you get kind of an idea of who came under suspicion from the internet, from online crimes, sleuth, from the now past defense teams, memo. We still will go through that. But obviously, that is going to be kind of on hold now. I will still continue to work on those. I will still continue to put those out. But if you have any suggestions of any newsy news stories, any things that you would like me to look on, I do have my email in my, I think, community post. So feel free to either catch me on Twitter or on the MLS Discord or anything like that. And then I will be on a Stabby Day tomorrow with Baker, and I will probably be doing some stuff with Sal. Now, Sal and EU are working to get up to their monetization numbers. They have been awesome helpers for me to get to my monetization number. So I'd like to help them. So let's start spreading those numbers around, and I will try to start helping them be hype men for them with my personality. I have no idea. I will try to get out of my comfort zone and be hype people for them and learn how to use the Twitter to be more hypey for them. But join me back here on Monday for newsy news Mo and Fry in the morning for current event, crime, court, and chaos. I will see you guys later. I might be on Nick's Finally Friday tonight if he has it. I don't know. I haven't checked a whole lot of stuff while I've been watching this with you guys. So I will see you guys later. Have a wonderful and safe weekend. Spread a little kindness in your corner of the world. That's all we can do in these crazy times. And so just do that. I will see you in a little bit. Bye, guys.